Extreme urgency is there.
What is the urgency?
Urgency is disconnection of electricity 20%.
No problem. Come
Urgent-
tomorrow. Come tomorrow is the mentioning date. Mention. Yes, call the list.
My lord, non-possible.
Tomorrow, today is not the mentioning date. Call the list.
But tomorrow is I shall see here.
Yes.
My lord, kindly may I submit one thing? Today I am filing the petition.
It is electric connection. You file it and mention it. Why the leave is required?
My lord, because my lord, there are
Yes.
totally 60.
Who is for the petitioner?
I for the respondent, lordship.
Why to be mentioned?
Non-prosecution, my lord.
Where is the instruction?
My lord, make it not today. Make it not today, I will bring, my lord.
Why you persons are mentioning it without any instruction?
My lord, instruction is there, I could not print out, my lord.
I will go to your chamber. I will take your printout.
No, my lord, no. Kindly make it.
Keep after 1 week.
Respondent.
My lord, this I had mentioned, my lord. I want to withdraw to file afresh because, my lord, this was a draft unsettled copy filed, my lord. There are mistakes, my lord, in the petition.
Yes.
And it,
For the respondent.
Well, I for the respondent.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner raised for withdrawal of the presented application with the liberty to file a fresh at the learned counsel for the parties. WPA 24922 of 2025 is dismissed for default, dismissed as withdrawn. Liberty to file a fresh.
Deeply placed.
Lord, item number 7, I am appearing for the petitioner, my lord. My lord.
Yes.
Ball.
Your Lordship, I appear for respondent number 4 and 5. I am led by Mr. Siddhartha Banerjee.
Sir, why mention?
My lord, in this matter, my lord, AIB and admit card, my lord, issued enrollment number has been wrongly published, my lord.
Yes.
My lord, may I just take over with your honor's leave? My lord, the innocuous prayer is that, my lord, I have been appearing for the ensuing AIB examination, my lord, so is scheduled to be conducted on 31st of this month. 30th, my lord. Now, the only thing is this, my lord, I have done everything within time. Now, what has happened, my lord, if your lordship kindly takes page 23 of the writ application, my lord, annex to P5, your lordship will find the admit card issued by the, my lord, the AIB authority, my lord. My lord has got that?
Yes.
My lord. Now, my lord, the only thing is this, my lord, that if your lordship sees, my lord, the fourth column from the top, my lord, enrollment number, thereafter enrollment number, my lord, there's a F number given, my lord. Now, my lord, this F number, my lord, they have missed a number in between. My lord, only praying for rectification of the same.
What is the number, actual number?
The actual number is, my lord, appearing at page 20, my lord. My lord, will see enrollment section written in bold, page 20.
Yes.
My lord, on the left hand side, just below thereafter, number F2939, thereafter stroke 2972, stroke 2025. My lord, this is the correct number, my lord. Now, my lord, the only thing is this, I have demanded justice and made a representation. Now, my lord, will kindly see the schedule which is appearing at page 21, annex to P3, my lord.
Yes.
My lord, the fifth column from the top, last date of correction of registration form. Well, that has gone. Now, my registration, the inputs which were given in the registration form were not incorrect, my lord. So, I do not come under this purview of the schedule. Well, I had only one remedy to come before your lordship, knocking the doors under this high prerogative extraordinary jurisdiction, my lord. Only
Appearing for the Bar Council.
Your Lordship,
What?
for
Bar Council of?
West Bengal, your Lordship.
For the Bar Council of India.
my lord, service has been effected, my lord.
This is issued by Bar Council of India.
Yes, my lord.
So he is the necessary party.
My lord, they are, my lord, from.
Have you served?
Yes, my lord. This is the affidavit of service, my lord. speed post পৌঁছেছে না? My lord, we have served in both ways, my lord, email as well as speed post. My lord, speed post has been dispatched, it has not reached, but email shows my lord service.
Advocate who usually appears,
And my lord, Abhishek Kankani. And Mr. Kankani, my lord,
Yes, Mr. Kakrani, where is that?
he appears
served
generally,
the-
my lord, we have served him personally, my lord, hand service.
Do one thing, you issue the notice, come at 11:30.
I'm so grateful, my lord.
Your Lordship.
এটা আমাদের নয় তো?
Lordship, I am for the plaintiff. Petitioner, Lordship. Affidavit of service. Lordship, the petitioners has been in the possession of the said land more than 40 to 50 years. Lordship, the petitioner's father had a record of Borga in the year 1970, which is there annexed in page number, Lordship.
What is your prayer?
Lordship, my prayer is that I have been in long-standing possession of the land from my ancestors. They have cultivated the land as borgadars of the property, and thereafter the property was wasted. And after the wasting of the property, the petitioners had tried several times for the patta settlement, and they had made several representations, Lordship. The representations is there is in page number 63, 64, and 65, and 66, Lordship. So all the representations are there, and instead of all these representations, the grant of patta was not allowed to the petitioners. And thereafter, after several time, till the time the petitioners were continuing cultivating on the land, and possession was not being affected by anyone. Any possession was not claimed by any other party at that time. Suddenly, Lordship, the local police station coming to the petitioners and threatening them to vacate the land immediately, so that there will be a construction of a local new police station, which will be under the Chachul police station, a police station, namely Malatipur police station, that will be constructed in that plot of land. The petitioners were not informed previously by any notice. Now the police officers are now coming and just giving a notice. The notice has been annexed there in page number, Lordship. Kindly, Lordship, give a minute. Lordship, they are now encroaching the property, which is the photographs has been annexed in page number 80, just with the tractor. And Lordship, the police officers are saying that they are sieving mustard seeds in the said land. That police officers are coming and they are saying that we will cultivate the land now. You have to vacate the land as of now. Police officer they themselves are saying that we will cultivate the land for growing mustard seeds. Then, Lordship, another representation was sent by the petitioners to their advocate. It is annexed in page number 76.
What is the application filed before the West Bengal Land Reform?
Yes, Lordship. It is for the correction of record of lands, because the petitioner's father has a Borga record. And thereafter,
Father or? Petitioner father is?
was the Borgadar of the land. And they had the Borga record on their name. Thereafter, the petitioners were eligible for the patta settlement. That is why a matter is being filed to the LRTT, and that matter is pending, Lordship. Coming 5th December, date has been fixed here. The matter will be heard before the 4th judge.
Why you not wait for interim order before the authority? Tribunal application is pending. How the writ petition is maintainable now?
Lordship, the matter, Lordship, it has been filed in the LRTT for asking for the correction of the records. Thereafter, now the police is coming and encroaching the property and saying to vacate the land. That police officer will sue master seats.
So you get the interim order from the land and tribunal.
That I will go, Lordship. But the police officer now coming fortnight and coming threatening them to vacate the land. That is also not fair, Lordship. Thereafter, Lordship, if the petitioners seek for the peaceful possession until and unless any further order comes. That is the only prayer, Lordship. And if you see the judgment of the Supreme Court in Lordship, the judgment of Odisha High Court in Sri Rajkishore Panda, that long-standing possession is in favor of the patta holders. They give them the right to for Patta settlement.
Which paragraph?
Yeah, sorry. Pardon, Lordship, Odisha High Court judgment.
Madam, this is the second appeal under section 100 of the CPC. It is not in the writ application. You go file a suit and claim a adverse position. You are more than 30 years you are in occupation of the government land. It is
Lordship-
unfair. Kindly see the cost title.
Lordship, kindly a
Appeal
direction.
under section 100 of the CPC.
Lordship, kindly a direction to be given to the police officers
Yes.
not to disturb any peaceful possession of the petitioner's lordship.
Question is, my lord, who has come up before the court, my lord, to establish his right, who has no right, and my lord, allegation against the person, otherwise who has right, who is the owner of the land, the state government. The thing is this, my lord, as it appears from the writ petition, my lord, no locus, no right, because of the fact it appears that a single representation way back in 62 is said that having been the Borgadar, so the patta be granted. 62 thereafter, my lord, according to the writ petition, I am not on any our document. According to writ petition, 2019 and 2020, another representation by the heirs that we are in possession. Then no other document, no portia, nothing. All it appears in our favor that it's a vested land at Khotiar number 1. Now, my lord, under these circumstances, my lord knows that my lord, in terms of the, my lord, the WBLR Act, my lord, the possession of the vested land, the government, in their intra-department note, my lord, the possession can be handed over to other department. And exactly that has been followed. That is, my lord, at page number 45 of the writ petition. Lordship, kindly, I am relying on his document, I am not any other. The page number 45, my lord, that is 19th of March 2025. The vested land for the purpose of construction of police station, that is for public purpose, my lord, the handed over from one department to other, that is the, my lord, the police department. Now he has come up and, my lord, filed that way pending, no interim order, nothing, because he knew very well that having not been, my lord, armed with any document that in possession, now all on a sudden said that vested land I am occupying. First of all, totally illegally. Even if he is there, he is claiming totally illegally. He is not in possession. There is no document, he is in possession. And now he has come up. Another thing, lordship, that a very important thing is maintainability of what fell from your lordship. My lord knows that application, my lord, the foundation is that my name be recorded. So that means under the West Bengal Land Reforms Act, section 51 and then followed 52. Now, my lord knows that no, my lord, the issue concerning the West Bengal Land Reforms Act can be adjudicated directly by writ court unless, my lord, they went to the land tribunal, just like my lord said, because the court has no jurisdiction.
Yes.
Now he has, my lord, claiming. The moment, my lord, he claiming an interim order, that means there must be at least, my lord, a token of adjudication. But court cannot go through that. Well, this is my submission, my lord. So kindly dismiss this.
Lordship, my only prayer is that the land has been, the land was wasted, that information was given to the petitioners after a long period of time. Lordship, the Rayat Pari that the,
Not necessity. Everybody has
Lordship,
to be informed.
thereafter
It's a
the
vested land. He has to inquire.
and Lordship, it is, if Lordship, if the records see that it is a agricultural land and they have been cultivated land
Not
for,
agricultural land as per the record. দিয়েছো তো রেকর্ডটা?
thereafter, Lordship, now the
per the
current
record.
situation, why the leave was granted, that the police officers are now coming to the land and they are now, Lordship, the photographs of the cultivation has been annexed, Lordship, and thereafter they are vacating the land without any.
The present writ application, praying for a direction upon the district magistrate and the police authority.
Lordship, only prayer is just to maintain the peaceful possession until any further order comes, Lordship, from the elected.
Peaceful possession.
The petitioner from the landed property without due process.
No
of
right
law.
to peaceful possession.
Due process law, and further direct the respondent authorities not to change the nature and character of the landed property. Petition has further prayed for a direction upon the respondents, particularly the PL and LRO, to forthwith consider and dispose of the petitioner's application dated 9th October 2023 for grant of patta settlement under section 49 of the West Bengal Land Reforms Act 1955 with respect of the land being Dag number 183, Hatan number 1, Muaja, Malatipur, PL number 129, PS Capital, Block 2, District Malda, in favor of the petition. Counsel for the petition submitted. The petitioner is in occupation of the property in question for the last several years, and subsequently the petitioner has made several requests for consideration of the case of the petitioner for issuance of patta, but that has not been considered. She further submitted, all of a sudden the police authorities have entered into the land of the petitioner and threatening the petitioner for evicting the petitioner from the said property. According, the petitioner has filed the present application, praying for a direction of the authority to petitioner from the property in question. Per counsel and advocate appearing for the state submitted that it is filed by the petitioner is not maintainable. It submits that by a notification dated submitted that the additional district magistrate and the district land and revenue officer Malda has handed over the possession of the property in question to the police authority
এটা তো আজকে তুলে দেওয়া হয়েছে না? এটা হাতে দিয়েছে।
for construction of police station in Chanchal.
And my lord, the last page of the document that I have handed over, it appears from the Porcha record that it is not, my lord, the agricultural land. In Bengali, it is, my lord, called Meda.
The Learned Counsel for the state
And he is not in possession also.
handed over the
And it's a vested land,
This is
Khotiyan number
not,
1.
not the agriculture handed
No,
over the
not the agricultural land. As per Porcha record, it's under Khotiyan number 1, that is vested land.
handed
and
over
he is
the
not in
document
possession.
and submit that the land in question is not a agricultural land. This is vested land. Vested land. And as such, the submission made by vested land police. He further submits that the petitioner has already approached the West Bengal Land Reforms and Tenancy Tribunal, praying for a direction for consideration and disposal of the application filed by the petitioner for grant of patta. Pending disposal of the application before the tribunal, the petitioner has filed the present writ application. According
আমি
to
কোথায় যাবো? 4 না 13?
dismissal of the writ application. At the Learned Counsel for the respective parties peruse the material from the court and documents submitted by the state. It is found that the land in question is not the agriculture land, and the authorities have already allotted the said land to the police department for construction of the police station. The petitioner has already filed an application before the tribunal praying for consideration of the representation for grant of patta, and the same is pending before the learned tribunal. This could also peruse the application filed by the petitioner before the tribunal, wherein the petitioner has also prayed for an interim order restraining the respondent for interfering and disturbing the possession of the petitioner over the property in question. This could find that the authorities have already allotted the land. This is not the agricultural land, and the land in question is already been allotted to the police department for construction of the police station. The petition has already initiated a proceeding before the tribunal. Thus, this court finds that the writ application filed by the petition is not maintainable. Accordingly, the same is dismissed. However, the dismissal of the present writ application will not prevent the petitioner to approach it to proceed with the application filed before the tribunal.
Might. Get fullers. Get.
Either dismissed will go on and proceed for it.
Lordship, I am for the petitioner. This is a restoration application. The petitioner carried out work of road construction under Durgapur Municipal Corporation.
When it was dismissed, where is your application? By order, which order?
Order dated 2nd July 2025, passed by Lordship Amritaben Sinha.
There is paragraph 70.
I am for the corporation, madam.
Another state. Was listed item number 680 in the monthly list. For June 25, the matter was taken over her lordship, then arising health, blood pressure, advocate on regard could not present. Yes.
I am
What is the matter? What
The
is
matter-
the application?
It will be a specific
Lordship,
contract, my lord.
the petitioner was awarded a contract for construction of road work. He duly completed the work within the allotted time, and
When
he
the
received.
contract was awarded to you? When the contract was awarded?
By way of an agreement, madam.
2019.
Yes.
19. Correct.
Order issued on October 2020.
2020?
2020. Work order issued 13th of October 2020.
Lordship will find it at page annexure P2 of the writ petition, page 14,
T2.
page 19.
30th October 2020, work order was issued.
Yes.
For 365 days, you have to complete the work. Improvement of the bitumen road. For the road, 365 days.
And it was not
Then
satisfactorily
what has
completed.
happened?
And the work was duly completed within the allotted time, and the fact of completion has been admitted by the respondent corporation
How you
by issuing a completion certificate.
correct? When the
and-
completion certificate was issued?
Completion certificate, Lordship,
December 2013, 2023. Then what has happened? Then
Uh,
you made a
af-
representation.
yes,
How much
eight-
amount you have received?
8,27,000 was short paid
Ah.
from the bill of the contractor. I'm going by the admitted value of the corporation. And during execution of the work, he was asked to do some additional works,
Yes.
which he did. And the claim on account of that is also there. So together it comes to 36 lakhs. And in addition to that, he is to get a refund of his security deposit because the defects liability period of 12 months has expired. And according to the terms of the agreement, you will find that in page 24, Lordship, second para of clause 16, it is to be refunded within 12 months.
Then
That is it. The money is pending, and the matter
which
of
amount you received?
the amount we received is
Because as per your completion certificate, the total value is the 84,47,000,
Yes.
8 crore 44,74,199.
yes, Lordship. We received 8 crore 36 lakhs 46,933.
Where from you get?
I beg your pardon,
amount?
Lordship.
Contractual rate. Where from you get? You got the amount. Which page?
Page 4 of the CAN application, para 3.
Can application.
I saw. Yes. No. In the CAN application.
Where is your writ application? What you mentioned?
Same thing, Lordship.
Where is that? Where is the document?
In paragraph 12, we have stated.
আপনি কেন বলছেন? আপনি তো স্টেটে।
Fact.
ফ্যাক্টটা উনি বলুন। স্টেটের ব্যাপার বলবেন কেন? আর আপনি তো এখানে কোনো ইম্পর্টেন্ট পার্টি নন। পার্টি তো কর্পোরেশন।
Lordship will kindly take up page 5 of the writ petition, paragraph 12, read with paragraph 11. The petitioner claimed progressive RA bills, and out of the said completed value of purportedly 8 crore 44 lakh 74,199.
You see the short payment of more or less
Total-
8 crore 44 lakh 70 minus 8 crore 30. So 8,26,266.
Was due on account of the bill.
Ah.
In the meanwhile, he executed extra work,
Ah.
One was pertaining
Extra
to
work is admitted.
yes, Lordship.
Where is the admission on extra work?
No, that has not been disputed by the respondent corporation.
That has not been
Let-
admitted also.
Yes, it is not admitted. How the writ court can go into that?
And there is an agreement also with the petitioner. There is an agreement.
And then the security deposit part of it is pending.
When you handed over the work,
It has been notified to them by letter. The letters have not been controverted by the Durgapur Municipal Corporation.
But my writ petition, I have to have a copy of the writ petition also, and I have to take some instruction. So whereas I came to learn that there is an arbitration clause in the agreement also.
where is that? The agreement how it? This is a condition of contract. There is a contract. Where is the agreement clause? There is a condition of contract.
In the agreement itself, it is written. I can come with a arbitration clause. আছে তো? Copy নেই writ petition এ।
There is no arbitration clause here, Lordship.
It's an arbitration.
No.
Then I have to check. Let me give a copy of the writ petition. I will come with you.
The Lordship will find the
Today
agreement.
I was prepared with a restoration. Restoration that may be allowed. No admission.
No, this court restoration, then I will dispose of total. Otherwise, again, then it will be pending in the dock of the court.
As your lordship.
Lordship will find the agreement at page annexure P3, page 20.
P3.
P3, page 20 of the main writ petition.
Yes.
The entire agreement is there. There is no arbitration clause.
I have to check the agreement. I have to come with the writ petition valid.
Why you are not appeared? The landed council for the petitioner has filed the present application being Can 1 of 2025, praying for recalling of the order dated 2nd July 2025, by which the writ petition being 2167 of 2024 is dismissed for default. Council for the petitioner submit that.
Arbitration clause nahi.
Arbitration clause nahi.
That the
Arbitration
on
clause only
on the said date, the matter was listed as serial number 680,
clause
680 in the monthly list for June 2025,
Clause 25 is
and when the matter was taken on 2nd of July 2025, but on that said date, due to ill health, the advocate not in could not appear before the court. Accordingly, the matter was dismissed. But the landed council for the parties has find that sufficient cause has been shown for non-appearance of the petitioner on the date fixed on the date of hearing. Accordingly, order dated 2nd July 2025 is recalled. WPA 21647 of 2024 is restored its original file. Can number 1 of 2025 is disposed of. Let the WPA 121647 of 2024 place it under the heading adjourn motion on 4th of March 4th of December 2020. Yes.
My lord, it will be returnable on
4th December.
a copy may be
Give
I
the
will
copy.
at my cost, no problem.
Give the copy.
I have given a
Give, otherwise I will dismiss on the next day if you will not so. So we will take instruction.
all right.
Shall I record? The petition is directed to serve the copy of the writ application along with the annexure to the London Council appearing for the Kolkata
Of the Durgapur Municipal Corporation.
Durgapur Municipal Corporation. In course of
By tomorrow, no problem.
Lordship, it has already been served on Durgapur Municipal.
You required 10 lakh rupees. Give the 100 rupees. You
No,
It's not a question of money, Lordship.
no problem, I will spend that.
He has misplaced his place.
Misplaced. You have dismissed for the
okay.
person to return.
Call. Huh? The application say hai na usko complete.
For the state.
Malad, in
Which
this
one?
matter, during the Malad, the pendency of this writ,
Which matter?
one.
Item number 1.
Malad, that during the pendency of the writ petition, some improvement has been done.
Yes.
So, my lord, this is the authority concerned admitted that I have been communicated a letter that I am entitled to get the amount which has been paid in the writ petitions. So now, my lord, this is the
The block development
My lord, he is here. He is appearing for surety. He is there.
See, anybody is present?
দেখা যাচ্ছে। Admit. Vidya Mathurapur too.
so now, my lord, only my prayer before your lordships, kindly consider one thing.
Yes, where is the report?
My lord.
My lord, this the I have been also communicated. My lord, this the report which has been, my lord, is admitted that I am entitled to get the certain amount since 2021.
Hmm.
So now the similar order which has been passed by against the same video by a coordinate bench of by my lord Justice Vivas Bhattonayok, that the for wants of fund, well, there is a shortage of fund, they are unable to, my lord, this the make my payment. So now it appears from the communication made by the video, he sought for, my lord, the certain amount from the district magistrate. The same order which has been passed by a coordinate bench. Only, my lord, is a kindly gone to, my lord, I have sent to my learned friends.
My
My lord,
lord, I have gone through the particular order, but the thing is that
My lord,
so far as the rate of interest is concerned, my lord,
my lord,
I'm praying for my lord legal interpretation of the same, because it will have put an I mean, it will be a burden for the I mean, government exchequer, my lord.
my lord,
May that be considered in a liberal way.
my lord, this is the my lord, may I submit one another thing, my lord?
My lord,
So now, my lord, this is the interest which has been considered against the said video, only 6%. Now the division bench approach before the division bench. Division bench held, my lords, another coordinate bench, 9%. So now, my lord, I am not bargaining before your lordships. The same order which has been passed at the rate of nationalized bank interest rate, I agreed that.
my lord,
That order which has been handed over before your lordship, I have shown to my learned friend, my lord,
my lord, I have seen that, my lord. I'm
my
not,
lord, this is the kindly see that
I'm not
division
denying
bench.
that part,
My
but the
lord,
thing
just
is, my lord, the facts may be little different. We are not challenging the maintainability as it is appearing in the order. My lord, the thing is that there had been some
What is the
miscommunication.
total bill amount?
my lord,
What is the total amount?
my lord, the total 2,72,000.
Ah.
So now since 2021, the completion certificate they have admitted, my lord, is since March 12th of March 2021. So now the another coordinate bench which has just now handed over that, my lord, this is the 6% interest and directing to the, my lord, directed to the district magistrate to sanction the fund. Otherwise, the person why he will suffer.
You do one thing, you appear on behalf of the state. If you are you have taken the fee from your petitioner.
Well, I appear on behalf of the petitioner.
You are arguing the matter on behalf of the state. What is your case?
No, my lord, I have been communicated. I have been communicated a letter.
Court will see whether you communicated, whether they are appearing.
Lordship.
It is a duty of the court. What is your case you plead?
My lord,
If you are mingled with the video, I am dispensing the application. You go to the video and take the amount.
No, I am not on that. I come
Why
people.
you are supporting the video?
I am not supporting.
Since the case is taken, you are taking yes, video is telling that, he is telling that, she is telling that.
No, he admitted that I am not in position.
For this, if you are coming to the court, you come with a clean hand without share with the administration.
I will not accept the administrator. I am entitled to get the interest.
Yes.
That is only.
Yes, where is the video? Let the warrant be issued.
My lord, I have instructed him to be appear. He
See, or he.
My lord, he is there.
Sir,
Who is the video?
sir, myself, sir. Can you, sir?
Said when you will release the amount, otherwise I will pass appropriate order herein now. Tell
Sir,
me the date. I will fix the date, fix the matter on the said date, along with the interest.
Sir, due to want of fund, sir,
I don't want here with the want of fund or whatever. You have taken the service of the petitioner. So petitioner has completed the work. You have given the completion certificate, and now you are telling the fund.
Sir,
Otherwise, I will tell let the amount be deducted from your salary, and when the fund will come, you will take the fund that salary from the fund.
my lord, I want to state
Yes,
one thing.
what is your basic way?
Sir,
What is your basic way? I am telling how much amount you are receiving from your salary.
Sir, I want to state one thing, sir.
Yes.
I want to submit one thing, sir.
Yes.
Please, sir, kindly allow me, sir.
Yes, yes, tell me.
Sir, I am a newly joined video. I have just joined on 3rd of November. My predecessor was present at the time of these things. So, sir, after coming, I came to know that we are lacking of funds, sir. And after getting your honorable order, sir, I already communicated this to our DM to give us money, and I don't have any intention to not giving that petitioner the amount. I am ready to give them the money they demanded as per their documents. Sir, I verified those documents and I am sent letter to DM for giving us money, sir. Sir, the situation is quite difficult, sir. Sir, I have stated all those things in my affidavit, sir.
The by an order dated 9th of September 2025, this court directed the block development officer, Mathurapur Roman 2 Development Block, Bakultala District, South 24 Pargana, to file a report by way of affidavit. But the block development officer has not filed any report. Again, by an order dated 4th November 2025, when the matter is called, learned counsel for the state has prayed for time to compliance. The order dated 19th of September 2025. Again, the matter was taken on 18/11/2025. The order dated 19th of September 2025 was not complied with. Accordingly, this court, by an order dated 18/11/2025, directed the block development officer to appear before this court through virtual mode today at 11 a.m. and also directed to submit the report. Full stop. In compliance of the order dated 18/11/2025, the block development officer is present through virtual mode and had filed the report. From the report, it is mentioned that the BDO Madhupur -2 has already sent a letter to the district magistrate within brackets South 24 Parganas praying for arrangement of fund for payment of the pending bill of the petitioner. Full stop. The block development officer in the report has further stated that he will clear the entire bill of 6,57,000. Which report you have filed?
My lord, I think it is the next matter, perhaps.
Huh?
Shunjit Das, it is my 2 lakh.
Can you see page second page? That is also the second another
2,72,000, my lord. It should be.
Sir, it would be, sir, 2,72,000, sir.
No, where kindly see the report. That kindly see page 2, paragraph 9. What you mention?
Sir,
My lord, it is the very next matter, which is the similar matter. Oh, my lord, in that amount, that is 6 lakh, or that is 6,57,000, 57,586. And so far as this item number 1, Shonjit Das is concerned, it is
2,72,609, sir.
609, my lord.
What is stated? Nothing is stated. Pending. What is stated? This he stated that amount has been sent to the magistrate. Where about this writ petition? See the report. Paragraph 8, he has mentioned about the amount. Where is the further course of action?
Sir, this letter is sent by me after knowing the situation, sir.
This is 6,57,000. This is not with regard to this matter. 6,57,000, which matter?
My lord, it is the next matter, item number 2, my lord.
Where is the 2,72,000?
What
What you are doing?
My lord, so far as this,
Mistake made by us. ভুল হয়েছে বুঝতে পারছো না Sir, kindly see, sir, point number 8. I have already mentioned, sir, 2,72,609, sir.
So what has happened? Further course of action, what has happened?
Sir, after sending a letter, I did not get any information from the district authority, sir. Since the
Submitted the report.
এখানেতে প্র্যাকটিস করেছে এই তো করে
Second paragraph. Report. But you get it in? It reveals that the authority, the respondents have not denied with regard to the entitlement of the petitioner to a sum to the sum of rupees 2,72,609, but have submitted that submitted that fund is not available with the department, and accordingly a request has been made to the concerned authority for release of the fund so as to enable the respondents for this release of the amount in favor of the petitioner. Let the report be kept with the record. Considering the full list, Learned Counsel for the yes, what is the submission?
My submission is that so far as since the BDO has already recognized the amount, there is nothing to come in the way. All I'm praying for, my lord, the interest portion be considered liberally, my lord. It will put a pressure on this.
Relaxation, no, is entitled because you are taking a time, fund is not there, you are taken.
My lord,
You only you say how much time the court will fix the time.
The deficiency, the error has been done by the predecessor in office.
Yes.
But well, he has come in the way, just joined.
I am on the post. I don't know who is he or who
My
was
lord,
the
I
earlier.
leave it.
The court is concerned with the post only.
I repose fullest confidence on the.
Court is not having any personal grudge of any
No,
person.
certainly not, my lord. Certainly.
Police. Learned Counsel for the respondents submit that as there is no fund in the department, and whenever the fund will be sanctioned, amount will be released in favor of the petitioner. Learned Counsel for the petitioner has relied upon an unreported judgment in the case of Buddhishwar Haldar versus State of West Bengal, passed in WPA number 13084 of 2023, dated 13th March 2025, wherein the coordinate bench of this court has allowed the interest at the rate of 6% per annum from the date of approval of the actual payment. Then it was enhanced.
It has been enhanced by a division bench 9%.
We further submit that.
The judgment can
So the coordinate bench has allowed the 6% interest, but the honorable division bench has enhanced the interest.
not against that order. Another coordinate.
I
agree.
At the Learned Counsel for the respective parties, peruse the Learned Counsel for the respective parties as well as the video person appear in person through virtual mode, as well as the report submitted, and consider the report submitted by the video. This court find that there is no dispute with regard to the entitlement of the petitioner to a sum of rupees 2,72,609. The only reason which the authorities have shown that the amount could not be released due to non-availability of the fund in the department. The block development officer has further stated that he already requested the concerned authority for release of the fund. Accordingly, this court release of the fund. Accordingly, the writ petition is accordingly, considering the report submitted by the video, the writ petition is disposed of by directing the Who will release? The video will release. Who will
My lord,
release?
video is the competent authority to release the fund.
Directing the, who will release the amount? Video, you will release.
Sir, after availing the fund from DM, I will release the amount, sir.
The block development officer is the director. Who will release, who will approve the fund?
DM Sahib is the authority to approve the fund.
Who is the authority? Who is the authority? District magistrate.
Sir, he is the authority to
Disposed of. Directing the district magistrates, South 24 Pargana, Alipur, Kolkata, to immediately approve the fund within a period of 4 weeks from the date of receipt of this order, and immediately after this approval of the fund, the respondent number 3 shall release the amount in favor of the petitioner within a week thereafter. Full stop. The respondents was also directed to pay the interest at the rate of 10% per annum from the date of completion of when you have made when the last payment was made.
Nothing.
No payment was
My
made.
lord, the page 12, my lord, kindly see the completion certificate.
When? From the date? Page 12.
Page 12 and 13 also.
From
13, my lord, sorry,
from the month of April 2021 till the
21.
payment is received. From the month of April 2021, that is from the date of completion of the work until the realization of the total amount.
Grateful to lords. Mala, I am sorry, Mala. I am extremely sorry, Mala.
Personal appearance of the video is dispensed with.
Item 2.
My lord, this the
Similar matter, my lord. Amount is different.
amount is 6 lakhs.
It Joseph.
उसमें report था.
No.
Same होगा. Amount only 6 lakhs. Well, what is the amount?
My lord, the
sir, the amount is 6,57,586, my lord.
And where is the completion certificate?
my lord, this the completion certificate they have. My lord, this the kindly come to page 18 in my writ petition.
From the month of March 2021, that is the date of completion.
Grateful to lords. Grateful to lords.
My lord, in this matter also the personal appearance dispensed.
Stop.
Yes.
Extremely grateful, your lordship.
Next.
Item number 10, I have appealing on behalf of petitioner. This is registration application. The matter was assigned before the Honorable Justice Kapoor.
Item number 10. What is your application for?
Applications, it was all on a certain, it appears in the paragraph 6 of the application on 24th October 2020. On that day, learned advocate was absent on account of her illness. As a result, when the matter was ordered,
Page number, paragraph.
paragraph 6. Page 8, this is the order.
The petitioner has filed the present application. What is your case?
Actually, it is a very simple case. The petitioner has
What you have prayed for?
completed the paragraph.
Again, money suit.
No. As per, he has completed the.
Okay, respondent is
What?
not here.
As
The
per,
petitioner has filed the present application, praying for recalling of the order dated 24th October
he has
2025.
completed the work, but they have not taken any
Wherein
step to
the
pay
WP
the least
number
amount of money.
22841 of
only-
2024 is dismissed for default. Counsel for the petition submitted
Paid only.
that the matter was
The losses can come.
all of a sudden the matter was listed before the
Page
court of 24th
paragraph
of
7.
October 2025,
The lordship,
due to which but the learned advocate for the petitioner could not noted the list, and as such he failed to appear before this court accordingly.
Paragraph 7.
Petitioner
Of my lead application.
at the land counsel for the petition, this court finds that sufficient cause has been shown for non-appearance of the petition before this court. Accordingly, WPA number according order dated
Represent consent before the concerned authority, that is the record, that's what number 2.
WPA
But it is
2284
governor of Indian State to read the rest of
regional
the
5 police can number sensations dismissed disposed of. Yes, next.
My lord, I appear for the petitioner, my lord.
Court on December state respondents.
My lord, your lordship remembers, my lord, yesterday my senior has submitted briefly, my lord, this is the matter why the petitioner has been blacklisted from a tender, my lord, without being given appropriate
Yes,
opportunity
yes.
of hearing.
Taken who is for Jilla Parishad? Taken instruction.
Milord, we have submitted our submission, Milord, yesterday, Milord, may I have a lordship kindly?
No, Nadia
My
Jilla
learned
Parishad.
junior is there.
Yes, yes, no problem, no problem. Yes.
My lord, I want to place the report, my lord.
Yes.
First, my lord. My lord, page number 2, paragraph number 3A, my lord.
Page number 2.
No, my lord, page number 2 of the report, my lord, file on behalf of the respondent numbers 1 to 4, my lord.
Report. When you
Report,
file the
ma'am.
report?
Report in connection with the instant case, my lord.
Yeah, formed on 25th of April. Affidavit in reply.
No, my lord.
Report.
Report, my lord.
1 to 4.
24.
Yes.
1 to 4, my lord.
Yes.
3A, my lord.
3A.
My lord.
Yes.
May I please submit? My lord. At the very outset, it is humbly submitted that the sub-assistant engineer of the Nadia Jilla Parishad, namely Sri Sudeep Kundu, was physically assaulted by Sri Anirban Ghosh, who is also one of the partners of the petitioner company, my lord. In presence of other partner, was continuously encouraging the petitioner herein during commencement of the said physical assault between the petitioner agency, is illegally demanding certain bills in their terms, my lord. What happened, my lord? They were assigned to
Leave aside all these things.
my lord.
Two things you tell me.
My lord.
The assaulted is a very bad man.
Well, my lord.
Cannot do that.
My lord. My lord.
Government officers should not be assaulted by a private person.
My-
Even a government officer cannot assault the
No
government.
one
servant.
should be assaulted.
That is very bad thing.
Very well.
Correct.
Well,
Where is the inquiry?
where is the my lord?
Inquiry. First thing. Where is the so-cause notice issuing? Yes, you have assaulted my officer, so you are not competent to continue the work. So-cause. Where is the so-cause?
No, there was a resolution and person to which the notice.
Resolution, you may take anything. You may take anything. You may take hang. Pass an order to hang. My officer has been assaulted, he should be hanged. And you hang it. But he should be given an opportunity. You will be hanged, so and so did give opportunity. Why should not be hanged? Where is that?
Well, that is
Because it is your document. In the RTI, you have supplied, your authority has supplied. These are the three things is to be completed. Where is that? You show me that has been completed by you. Then nothing remains.
My lord,
that is the only thing.
What I am on, my lord, may I say something? My lord, if your lordship remits it back to the authority, so they can give him an opportunity of hearing and take a decision. And your lordship fixes up a date, we will produce the decision.
The order is before this court. Now, this court has to only adjudicate whether the order is sustainable or not.
The process of
And first thing. Second thing, you cannot take further. Why? You would practice in the criminal side? No. No. If a government servant is assaulted by a person while performing a duty, only your police authorities have registered a GD. not under the provisions of the, I don't know new because I'm for the last 3 years I am not touch with the criminal law, but as per the old IPC it is a 332 or 353 and that is the non-bailable. You have not done so. So what inquiry you further do? If the FIR is registered, investigation is registered, the persons will be taken into custody, investigation, all report will come, that will be a suffice for you. Now today you cannot do anything. If I refer the matter to you also, it will be a result will be zero because police authority is not registered. You have also not pressed for registration of FIR. You are satisfied with the GD. And police, what the police said? Police is 156, some 136. That is old of 107. CRPC 107. That is a bond to keep it. That is only for the 6 months. Nothing else. What you will do? You have done the blunder. He has done the mischief. You have done the blunder.
What is out of that there has been
In hurry-burry.
It is an admitted position, Lord. He is assaulting a government
Admitted
officer.
position, but the court has to adjust.
And kindly make
If,
some observation.
you tell me if you send it to you, and that is not and as in which on which ground you can blacklist it. Where is your RTI?
Lord, kindly, it was given yesterday.
Yes, you have given yesterday.
The grounds are there. Page 5, Nodia Jela Porishad.
Just a minute. You file the supplement, you know?
Yes, I have filed a supplement. I have received
Yesterday.
Yes.
yesterday.
See, grounds for department. Grounds for
Page,
department, as per the above memorandum, submission of false and forged document. That is not there.
My lord.
Correct. Use of substandard defective material. That is not there.
No, they have
That is no at this stage. You may take subsequently that I am with regard to this. Now failure to comply with the contract of the obligation. That is not there. You have only your ground is only has assaulted your engineer at the place of work.
Yes, okay.
Well, that to my lord, 4th November is a holiday.
That is maybe contract work.
My lord, not even oral altercation, my lord, as per the report.
No, there is physical assault. The state report also says that.
So what you tell me?
Police does not say.
The court has given the option to you.
No, my lord, it is
You
it is a
cannot
token-
say the court has not given the
the
hearing.
token punishment that has been imposed, my lord, that should be imposed, my lord, upon someone who is assaulting.
But you miss the bus, sir. You miss the bus. What is the date of the incident?
4th of January 2020.
January?
4th of January month.
January 2025.
2020. 5.
Then
25.
you also cannot register an FIR now also. After 11 months.
This, my lord, is being done because of personal vendetta, my lord.
That is
My lord, this
different issue.
order should be quashed.
Assaulting
Blacklisting should be quashed, my lord.
Petitioner is assaulting someone, my lord, like this. This is not
But that the law will
That
take
cannot
its
be
own course.
permissible,
For
my
that,
lord.
my lord, blacklisting cannot be done.
assaulting not be permissible.
And what has
That-
fallen from your lordship on last occasion, my lord, I have read through the.
I appreciate that. That's why he's very bad man. Cannot do that.
I am getting a lot. I'm totally-
Cannot do that.
I'm totally-
But you have to act in accordance with law.
I give it to your lordship.
You cannot take.
Kindly make certain observations in this regard to this assault, man.
The petitioner has filed the present application challenging the. Where is the impugn order? Department.
Blacklisting order, my lord, at page, my lord, 25 of my writ petition.
The order issued by the Secretary Jila Parishad, Nadia Jila Parishad, dated 12th March 2025, wherein the petitioner has been blacklisted from all kind of works under the Nadia Jila Parishad. In the said impugn order, it is also mentioned that the petitioner has been blacklisted indicated. The petitioner submits that the order of listing against the petition has been issued without following the due process of law and without issuance without giving an opportunity of hearing to the petitioner. The petition submitted that after the impugned order of blacklisting, the petitioner has also made a representation to the Secretary Nadia Jila Parishad on 20th March 2025, requesting for recalling of the order, but in spite of the representation submitted by the petitioner, the authorities have not considered the request of the petitioner. The police authority, who has filed this state, the state has filed the report wherein it reveals that on receipt of the complaint of one, what is her name? Your engineer? Sudeep Shah.
Sudeep Kundu, my lord. This is Sudeep Kundu, written in the order, my lord, page 25. Page 25 of the writ petition. Whereas it has been reported by Sudeep Kundu.
And he's a sub-assistant engineer.
Yeah, no, it is important. In the order, in the impugned order, in the impugned order, it also reveals that one Sri Sudeep Kundu, sub-assistant engineer, sub-assistant engineer within back contractual, Nadia Jila Parishad, has been physically assaulted by the petitioner on 4th of January 2025, and accordingly a GT was lodged before the Kotwali police station by GT number 407 dated 6th of January 2025. Accordingly, the authorities have conducted a meeting of Nadia Jila Parishad, Purto Cargo O Pariban Satya Samiti on 27th of January 2025 at 2:30 p.m. And in the said meeting, it was resolved that the petitioner should be blacklisted. According to the said order was issued. The state has filed the report wherein it reveals that the Kotwali police station has initiated NCR number 119 of 2025 dated 14th of March 2025 under section 126/135 within bracket 3 of BNSS against the petitioner. Okay. Cool. Learned counsel for the petitioner further submit that after filing of the instant writ application, the petitioner has applied certain information under Right to Information Act from the Secretary Jila Parishad, Nadia Jila Parishad, and on receipt of the information, it is found that the ground of debarment is not with regard to any criminal action. The ground of debarment is only not against any criminal act.
Not the petitioner who has got it. Petitioner got this information from one person under right to information.
That's recorded. Yeah. Cannot be criminal action against the petitioner cannot be issued if any criminal case is initiated against the petitioner / contractor. The contractor can be debarred on the ground of submission of false or forged documents, use of substandard or defective materials, failure to comply with the contractual obligations, refusal to accept award or abandonment of the work, or misappropriation of the government supplied materials. Okay? The petitioner submits that none of the ground the petitioners have the respondents have blacklisted the petitioner not covered under the aforesaid grounds. The Learned Counsel, the petitioner has further relied upon, and petitioner in support of his submission has relied upon the judgment in the case of State Bank of India and others versus Rajesh Agrawal and others, and submit that the Honorable Supreme Court has categorically held that if the authorities are intending to blacklist the petitioner, an opportunity of hearing is required to be given, but in the present case, no hearing has been given. No opportunity of hearing is provided to the petitioner. Per contra, an advocate appearing for the Jilla Parishad submits that the work was awarded to the petitioner, and the petitioner has assaulted the Sri Sudeep Kundu, who was the sub-assistant engineer of Nadia Jilla Parishad. And he said assistant engineer reported the matter to the secretary, and accordingly an emergency meeting was called, and in the meeting it was decided that the petitioner should be blacklisted for his illegal act. He further submitted that the contractor cannot assault the officials of the Jilla Parishad. If he would have been any grievance against the sub-assistant engineer, could have been reported the matter to the competent authority, but instead of the same, he has assaulted the sub-assistant engineer at this spot. He further submitted that the complaint was also lodged before the police authority, and the police has also initiated an GD, and as such, the authority found that the petitioner is not. And as such, the authorities have taken a decision for blacklisting the petitioner. Anything further? No. Police. The Learned Counsel appearing for the state submit that a complaint was made by Mr. Kundu, and on the basis of the complaint, a GD was entered and inquiry was conducted. Subsequently, an NC case has been registered and was sent to the Learned Sub-Divisional Magistrate for further action. Had the Learned Counsel for the respective parties peruse the materials from the court. This court finds that the Learned Counsel for the respectfully, and this court cut the Secretary Nadia Jilla Parishad has issued the order of blacklisting the petitioner on 12th of March 2025 on the ground that on receipt of the complaint from Sudeep Kundu, a GD was initiated by the police of PS Kotwale, being GD number 407 dated 6th January 2025, and in the meeting of the Jilla Parishad, it was decided that the petitioner should be debarred and should be blacklisted, and accordingly has been blacklisted. Full stop. Admittedly, no notice or no hearing has been given to the petitioner before issuance of the impugn order dated 12th of March 2025. The petitioner, by way of supplementary affidavit, had submitted documents which he obtained under the Right to Information Act. As per the said document, it reveals that it reveals that the ground of department is are as follows. Page number 5 we have supplementary, yeah? से लेकर के यहाँ तक. In the said office report, it is also mentioned that issue of so-called notice to the contractor provided opportunity of hearing is also provided. The said report also provided that if offense is proved, suspension/debarment is ordered for a fixed period up to 2 years for the first offense and up to 3 years for the repeated offense. In the present case, the ground on which the petitioner has been blacklisted is not covered any of the ground of the said report. This court also find that no so-called notice has been issued and no opportunity of hearing has been given to the petitioner. This court further find that in the impugn order,
Page 25.
in the impugn order, it was held that the meeting was conducted, and after the discussion in the meeting, the petitioner was blacklisted. But the resolution of the meeting has not been supplied to the petitioner so that the petitioner can get an opportunity of hearing, to find an opportunity to file the reply to the said meeting. Considering the above, this court find that the impugn order has been issued without following the due process of law and without giving a personal hearing of the petitioner. And the ground on which the petitioner has been blacklisted is not covered in the report provided by the authority under Right to Information Act. Considering the above, the impugn order dated 12th March 2025 is set aside and quashed. WPS so is allowed.
Well, there is no FIR in this regard.
Recorded. This is not covered. Or what you further recorded?
But there is no judgment in regard to that.
Well, that he can take their own steps.
Opportunity of hearing is not necessary, man.
Recorded. It is made clear that if the authorities intend to take any action against the petitioner, the authorities are free to take appropriate action in accordance with law.
Yeah, great. In accordance.
That's all. Yes.
I apologize. Next in course number 11.
No, that's why I passed over by known. You are very busy person.
No. I also apologize.
I appeared from the Bar Council of West Bengal, senior member of the Bar Council.
What do you want?
Not only this slight rectification, I require an order of court. Milord, whatever be it, Milord, I take it, Milord, Mr. Kankani has furnished to me a document from the Bar Council of West Bengal, evincing one fact that, Milord, according to the Bar Council, Milord, 4-digit 2972 is not a part of my enrollment. My enrollment, according to them, is the first part 2639. 2939. According to them. Now, Milord, the difficulty would be, Milord, yesterday one matter came up before your Lordship's consideration. Milord, I had intended to move the matter. There also, if your Lordship sees, Milord, the All India Bar has indicated the entire roll number. As indicated in the enrollment certificate.
Yes, that is
the entire thing. This is the entire roll number. Now, another thing is, Milord, a Bar Council certificate issued by the Bar Council of India. One of my learned friends present here, Milord, also evinces the entire enrollment number.
It is self-attested for the
Entire enrollment number. Milord, it may be a case, I take it, Milord, Mr. Kankani said, informally, he informed me that, Milord, apparently, Milord, there was some problem at my end. In as much as, Milord, while filling up the forms, I did not, according to them, indicate the entire enrollment number. The enrollment certificate was, of course, there. Milord, what I request your Lordship, Milord,
kindly pass an appropriate order, my lord, subject to your lordship very gracious consideration, allowing, my lord, this slight rectification. Otherwise, there will be a problem. Problem would be, my lord, my Bar Council of West Bengal certificate, enrollment certificate, gives the entire number. The Bar Council of India right to practice in the event I my lord, successfully get myself acquitted in the examination. My lord, that certificate would have a different number, not the entire. So, my lord, kindly pass appropriate orders, my lord, so that this rectification is.
My lord, I'm not coming in.
I am
There's
not.
Only two things, my lord. Your lordship will kindly see, my lord, the first paragraph.
With the undertaking, she will join you as a judge.
Yes, yes, Milord, she'll be in a better position. Milord, I know Milord him for a very long time. Milord, it will be a pleasure for the writ petitioner to join him.
Yes.
I'm not coming in the way.
No.
my lord.
Milord, Mr. Banerjee has appeared. Milord, I have to leave.
I am also appearing. I am also
Mr.
appearing.
Prosun Datta has come
My lord, applicants' details, my lord, your
for a
lordship will
poor
record this,
petitioner represented by me.
so that our
I am also poor lad.
What you want?
I am a poor member of the bar.
Towards the bottom, your
Yes,
lordship
I
will
can.
record
I gone through.
that this is what she filled.
So I will clarify.
Yes, just
I am
kindly
clarifying.
that, my lord,
The
so that at
enrollment
least
number
our
shall be read.
have-
This.
Yes.
This.
This is what she had done, my lord, and this is the letter we received from the Bar Council of West Bengal. My lordship will kindly see this letter.
The one indicated in page.
This is for your kind information that Srimati such and such enrollment number F/2939/2025. Middle number is the letter serial number. Lordship will kindly.
So I will indicate that this may be recorded.
And after that one.
The
2972.
2972 be incorporated. Nothing else.
The petitioner has filed the present application praying for a direction.
এটাই তো বলা উচিত
Praying for a direction.
পার্টনার্স ইন্ডিয়া করলে আমাদের কি করা যাবে
এক্সাম এসে গেছে
এক্সাম তো এসে গেছে
For issuance of fresh admit card to the petitioner by incorporating the correct enrollment number as capital F slash 2939 capital F slash capital 2939 slash 2972 slash 2025 instead of F slash 2939 slash 2025. Counsel for the petitioner submit that the petitioner has applied to appear in the All India Bar examination, which is going to be conducted on 30th of November 2025. But when the petitioner has received the admit card, the petitioner found that the enrollment number is recorded as F slash 2939 slash 2025 instead of F slash 2939 slash 297 slash 2025. And thus the request for direction upon the All India Bar Council for correct the enrollment number so as to enable the council to appear in the bar examination on 30th of November 2025. Mr. Kakrani, an advocate appearing for the Bar Council of India, submits that the petitioner in her application has mentioned the enrollment number F slash 2939 slash 2025 and as such in the admit card the enrollment number is recorded as 29 F slash 2939 slash 2025. He further submit that on receipt of the writ application, a communicate the Bar Council has informed that the petitioner has not mentioned her enrollment number in her application as F slash 2939 slash 2972 slash 20. Due to which the middle serial number 2972 is not appearing in the admit card of the petitioner.
No, my lord, Bar Council of West Bengal has informed that this is the middle number, nothing else.
Acha.
Later serial. ওটা mention করো
The learned counsel for the Kakrani. No, কেটে দিন কেটে learned counsel for Kakrani appearing for the Bar Council of India submit that he has received a letter from the Bar Council of West Bengal
এটা বল
wherein it intimated that the enrollment number of the petitioner is F/2939/2972/2022.
This was an opportunity granted to all the students to rectify any mistake. Actually, can you record this?
Further submit that.
I made a tick mark, my lord.
Further submit that by a notification dated 28th of October 2025. 2025, it was notified to all the candidates who are appearing in the bar examination to correct their registration forms. But the petitioner has not corrected the same. And now at the flag end, the petitioner has come for correction of the enrollment number in the admission card. At the landed council for the respective parties peruse the materials on record. This court find that the petitioner has received the admit card wherein the enrollment number is recorded as F/2939/202. But the correct enrollment number is F/2972/2025. The said mistake has been absent because the petitioner has submitted her application by mentioning the enrollment number as F/2939/2025. The petitioner herself has not mentioned the correct enrollment number in her application. This court is without going into the further merit of matter, and that the examination is to be going on, is to be held on 30th of November 2025. And the petitioner has already applied for, prepared an application, filed an application for getting into, so that the petitioner can get an opportunity to appear in the examination. The only problem with the petition is that the enrollment number is not correct. Accordingly, the authorities are directed to allow the petitioner to appear in the examination, which is scheduled to be held on 30th November 2025, and her enrollment number in the admit card shall be read as F/2939/2972/2025 instead of F/2925. Full stop. By the written disposal of the certified copy. Yes, next.
Number 12. 12, my lord, I'm for the petitioner, my lord. This is that Rohingya matter, my lord.
12 and 14, similar issues involved. But they were convicted by a competent court of law, and subsequently there was an order for pushback. Now, my lord, we need 2 days. Give me, my lord, keep these 2 matters on Friday, because I need to take instruction from MHA, because we have already mailed them, but no reply has come as of now. And ASG is also appearing in this matter. It's a sensitive issue. My lord, kindly take up this matter on Friday.
When?
Day after tomorrow.
This is the 6th adjournment, my lord, on behalf of the Union of
I can
India.
understand the problem, my lord. It's a real, my lord, because the order passed by
because it is be affected to us.
Competent court of law, whether that has been communicated to the MHA or not regarding the pushback, but this we have to ascertain. Until unless that has been ascertained, my lord, the person already suffered 1 year, 3 months. The conviction period is over.
You have not constituted any committee under the Civil Act, Civil Authority.
Yes.
Because there is, I think, whether I don't know West Bengal.
But just give me 2 days accommodation. We'll sit with it and we'll see.
Under the Civil Authority, there is a law, a committee, or an authority. In other places, it is the superintendent of police of the concerned district.
Yes, but he is the nodal officer.
He
is the nodal officer in terms of the act, and but he has to communicate it with MHA for pushback of these persons. Whether that has been done or not, I need to take instruction.
And if it is taken, then he has to give the control over the convicts who has been released from the.
It is the duty of the nodal officer so that the pushback procedure is completely is done. That we need to sit.
My lord, if I may, my lord, right now, my lord, there is no pushback to Myanmar because these people, there is a genocide going on. These people
Not
are
pushback with regard, no pushback, because I am not on the pushback. I am on the, because once he has been completed his tenure, this conviction. So he cannot be in the custody. So he
Yes,
has
ma'am.
to brought on the civil authorities order, and but it is informed that there is no other place in the West
Yes.
There is no other place in West Bengal. but
West
there is-
Bengal, there is no detention camp as of now.
There is only in Delhi and Hyderabad, my lord.
As of now,
is
your
very
lordships
surprising.
knows, my lord, your lordships knows that a lot of problem with the whole country is facing lot of
It is
and my
very-
lord, that too when the SIR has been invoked. My
I
lord,
was there, then I have initiated, then total building
my
has
lord,
been.
this matter we need your lordship's assistance. Then only we can, my lord, do something in this matter.
That is correct.
It's a very serious
By
issue.
taking-
It's-
Not only Rohingyas, all.
yes, all foreigners.
Taking that into consideration, my lord, the Supreme Court division bench had passed that order for them to be released on bail, my lord.
Repatriate nothing to do with the court. The repatriate it is the
Yes,
ministry, and this is the home ministry. They will take from the other country and they will sit together and they will do. But with regard to they cannot continue in the custody.
No,
Yes,
that
my
is
lord,
true.
they
That
are
is
not
one
being
part. But
seen
my lord,
judged,
can you
they
see the other
cannot.
part also? If today, my lord, if they are being released, my lord, they will be the unauthorized, my lord, the.
No, that cannot be.
That cannot be.
So
They have
that's
to.
why the civil authority.
Yes, if they
Civil authority will take, they will put them in that place, and the conditional order will be issued for their movement.
Yes.
For their
So, my
if
lord,
they
this
want-
matter, we need your lordship's assistance also, and we shall also apprise your lordship what is the instruction given by the AG.
Friday.
Friday. My lord, kindly keep this
Uh,
matter on.
As per the prayer made by the Union of India, let the matter appear on, or I am fixing on Monday. Friday, I think the.
Because additional solicitor general is leading me in this matter. Okay. Let me see, my lord, whether it is.
Kindly make it on Monday,
Monday.
My lord, kindly make the direction preemptory, my lord, because it's been 1 year, my lord.
Monday.
The union is still not submitting
My lord,
any
instead
instruction.
of Monday, my lord, can it be on Tuesday? Monthly is a monthly list. Your lordship can keep the
Tuesday.
matter on Tuesday.
Tuesday at the top.
Yes.
Under the same heading. 12 and 14. 12 and 14.
12 and 14.
12 and 14. My lord, may it retain its position. my
Yes, top I told.
lord. Grateful.
Yes.
12 and-
No, attack mat karo.
13 minute I pay for the petition. No, my lord, service to the.
My lord, at the very outset, my lord, may I say one thing, my lord, just a few.
You are appearing for whom?
I am appearing on behalf of the state, all the respondents, my lord. I received the brief
Hey,
in the
hey,
morning,
hey.
my lord. Your
My lord,
lordship,
this
that
is not my fault because my lord, we have served upon the state twice.
It has been given on 25th. Today is
No,
26th.
no. Mr. Kodon, please.
What is the prayer?
My lord, fact is very urgent. That is why, my lord, I mentioned you.
Instruction, my lord. Without instruction, I cannot.
My lord, the instructions are on record. My lord, what had happened was, my lord, we had a clinical establishment. Now, my lord, this clinical establishment was initially located in Kolkata.
Acha, that is not, Bardhaman is not allowing.
Yes. The entire machine is sealed.
Servicing.
Yes.
I need some time.
But in their presence,
This is the costly machinery.
yes.
My lord, I have
Instrument.
just
Costly
now I-
instrument, and
Yes,
that is related to the public health.
Yes.
Correct.
My lord, I am
And if it
fully
is not
agreeable
being
with
made
you,
servicing,
Sir Lordship,
Well,
my lord.
my machine goes.
May I come back after 2 days, my lord? My lord, let me come with the.
come with
instruction.
the positive.
Yes, my lord, I shall try.
And second one,
You tell me the date, time when your officers will be
yes,
available.
I'll do it in their
Fix the
presence.
date and time so that the servicing can be done in presence of.
No, my lord,
another so that they cannot use for the commercial purpose.
My lord,
And my lord,
lordship kindly come to page, my lord, just your lordship kindly, my lord,
my lord,
very serious issues is concerned.
no.
I am
Don't
not
extra
only allowing. That's what I'm telling. Only for the purpose of allowing the petitioner to let the servicing of the
Yes.
instrument
Otherwise,
can
my
be
lord, the machine is
done.
scrap.
Servicing of the machinery can be done, so machinery can be in the working condition.
Yes.
If in future he on the matter,
My lord,
what will the effect?
my lord,
And who will pay the compensation? State.
my lord, let me come back on Friday, my lord.
Yes, kind.
Monday.
Monday is the, my lord, Monday is the, my lord,
Monday is the monthly list. That is the difficulty, my lord.
Tuesday, my lord.
কালকে
Tuesday
এসো না।
Tuesday,
Well, it is from CMO, which let them come back tomorrow.
Tuesday to at the top.
Let the matter as per the prayer made by the council for the state.
Yes, my lord.
State, the case is adjourned. Let the matter appear on 2nd December, the Council for the State to come with the
But
instruction.
my affidavit of service be kept.
Affidavit of service filed by the petitioner be kept with the record. Next,
But under the same heading. Grateful.
same meeting, huh? Yes.
Yes, Lord, I appear on behalf of the petitioner. Lord, I have served. Yes.
The Reserve Bank of India.
Yes, yes. Lord, the issue remains, Lord, there is a service to that effect. Everybody has been served. Lord, if you Lordship kindly sees, there is a specific guideline of the RBI that the whatever will be the term loan, the process of realization the loan, that is guideline is there. If each and every bank has to follow the same. Now, my Lord, if your Lordship kindly sees, the Axis Bank Authority, my Lord, initially page 12, my Lord. Page 12, my Lord, they have issued the term loan facilities. My Lord, that is at page 12, 9,40,000. Now, my Lord, in the annexure 3, that is, my Lord, at page 18, my Lord, while issuing the term loan agreement, they have, my Lord, issued the schedule of payment. My Lord has got it. Schedule of payment. Page 18.
Principal interest.
Yes.
Also,
Everything has been breakup is there. My Lord, I was agreeable to that, and I have meeting the same. I am meeting the same demand as per the first schedule. Now, surprisingly, my Lord, in the month of March, yes, my Lord, 20th March 2025, that is at page 27. Page 27.
Yes.
My Lord, if you now, it has been raised up to 51,000. My Lord, it was initially flow up amount. My Lord, kindly see.
But it is correct. But the interest which you have taken the loan of the interest, it is a fixed interest or
My Lord, 14.8, it has been written. My Lord, that is at page 27. Page 26. Page 26, my Lord, if you Lordship kindly sees. APR, my Lord, 14.62%.
interest per annum.
Yes.
Interest per annum 13.50.
No, my Lord, 14.62. Interested, and the APR is 14.62.
Correct.
Now, my Lord, that was fixed. Now, my Lord, according to their chart, my Lord, I have to pay each and every month 34,754. Thereafter, reducing balance will come. But surprisingly, in the month of when I have got the loan, just, my Lord, just 2 months after, my Lord, they have issued a memorandum showing that I am to pay each and every month 51,000. That is, my Lord, at page 27.
Go amount 51,000.
51,000. My Lord, initially it was 34,000. Everything is same, and my Lord, what they did, the interest amount, kindly see, principal component 26,000. Here is also 23,429. Interest 8,000 so and so, and here, my Lord, 25,180. Surprisingly, raised.
Interest?
Yes.
Raised.
Rate. No, interest rate, interest component.
Interest component. 26. How it is 26,000?
My Lord, kindly see the page 26. Interest 8,325.
Correct.
Now here, my Lord, page 27. Now interest component 25,180.
Correct. That's I'm telling.
My Lord, suddenly, my Lord.
What is the interest on? What is the interest per? As per this, what would be the interest?
Or 25% interest. Now, my Lord, what we have done, because, my Lord, if thing is going on, my Lord, then I will be in difficulty. Now, my Lord, I have made the representation before the authority indicating that the realization of amount as per page 26 may be continued till the realization, till the completion, because ultimately term loan I am to pay it and they are to realize it. If this particular annexure 27 it is adhered to, then, my Lord, there will be an NPA, then surface a.
So why you are not gone to the appellate authority, ombudsman?
My Lord, no, my Lord, here, my Lord, the issue is, my Lord, ombudsman, my Lord, when, my Lord, the entire thing award or, my Lord, whatever is there, because I am willing to pay in a particular manner. My Lord, what they have raised at page 26. That is my humble submission. I have made the representation.
Yes,
let them consider. And
who is for the bank?
I pay for the bank, Your Lordship. At the outset, Your Lordship, I raised the issue of maintainability of the writ petition, Your Lordship, because it's purely a contractual dispute with a private bank, my Lord, so the petition should not be entertained. Now, with regard to this factual aspect, my lord, I would submit that my learned senior friend has probably not appraised the court with the actual facts, my lord. This, if my lord comes to page 12, which is shown by my learned friend initially, my lord, this sanction letter was for 9,40,000, which they did not accept because they either the petitioner had no requirement or had no financial capacity to pay that much repayment, my lord. So this sanction letter was never came into effect, my lord. Sub 7,40,000. I'm coming to the next sanction letter, my lord. And this is a unsecured loan, my lord. So no question of SARFAESI and everything comes here, my lord. Now this, along with this sanction letter, the repayment schedule which was given, my lord, that was due to some, because it was manually made, my lord, there was some error. Now why I am saying so, my lord, this will tally with the record, because the
So you're telling that the page 12 is not given effect to.
No.
So where is the next sanction order?
That is, my lord, page 20.
Yes.
That is, now it has come to 7,40,000.
This is their own admission. Kindly.
Yes. I am not denying that. I am not denying that.
They did not accept 9,40,000. Maybe they were not in a position to pay that amount, my lord.
Yes, exactly. That is page 20. Now, my lord, the breakup is there at page 26.
Okay, just let
Now,
me
why this repayment is
Let me
that,
hear.
my lord? I'll come. First of all, this repayment schedule, my lord, this contained an error, my lord. Now, why I am submitting an error, my lord? I'm coming to that. Kindly take up the page 20 sanction letter, my lord.
Yes, 20, I am there.
Yes, the term loan is for a period of 7 years, my lord. However,
Where you can this 7 years?
7 years, my lord. Kindly come to page 21, my lord. The tenure is 84 months.
Where it is?
Page 21, the second column, my lord. The second.
Proposed facilities, right hand side. It will be ended on 6th March 2032.
Yes.
My lord has got it.
Yes.
So tenure is 84 months, my lord. But the payment schedule is not for 84 months. It was payable quarterly, my lord. The loan amount is payable quarterly, not monthly. Though the tenure is 84 months, but the amount is payable quarterly, my lord. Now the first repayment schedule, my lord, due to
Where it is a quarterly, it is mentioned. It is a tenor of the month, 84 months.
Yes, my lord.
Correct.
But the repayment is quarterly, my lord. The first, if my lord comes to the second last column, the second last
Bottom, my lord.
Installment 27.
Yes, quarter.
It's quarterly, my lord.
Correct.
Now, due to error, while issuing the initial repayment schedule, my lord would find that only 28 EMIs are payable. It's not monthly, that would be only. But, my lord, due to error, my lord, the interest was calculated only monthly, because if the EMI is payable on quarterly basis, my lord, then for the subsequent EMI, the interest for the 3 months has to be calculated. But this repayment schedule, which is initially placed by my learned senior friend, my lord, that due to error, because it has been done manually, it contains only interest for 1 month, my lord, which is not the case, my lord. That's why, my lord, prior to even the first payment schedule, the first quarterly EMI, when it was payable, my lord, prior to that, the petitioner was intimated that there are some errors, and the schedule would be, the repayment schedule would be as per the page 27. It's there prior to, in June, the first quarterly installment was payable, my lord, and prior to that, they were informed. So it was within their knowledge, my lord, and this was just now the petitioner wants to take advantage of an error which was bona fidely committed by the bank. Even if we go into the accounts, my lord, what he has claimed that 25% per annum interest is being charged, that is totally incorrect. I can place both the comparison, my lord, that what would come. If my lord wants, I can place.
Yes. So see, page 26 is 14.62%.
Yes, this is
also, you have given the total installment and interest.
Yes.
Correct. Now you have, again, you come to 27. This is how it is possible. 27, which you mentioned, that is 3 months.
Yes, my lord. The interest for 3 months has been calculated, which would actually be payable, my lord.
3 months.
And initially, due to error.
If it's taken to 3 months,
yes.
So it is kindly come to 26. come to 26, interest is 8,325. That is for 1 month.
1 month. That is
1
for
month.
1 month.
So 3 months means 24,000.
24,000 and something.
26,000.
Yes, ma'am. Approximately. So this is the only difference, madam. And they have not if there was any confusion or they could have made representation to
Yes, my lord, I have done it.
Reserve Bank of
No, my
India,
lord, I have done it.
controlling authority, my lord. They have directly filed the writ petition, which is based on a purely contractual dispute.
Page 29, my lord, if you lordship kindly sees. Page 29.
Yes.
Yes, my lord, I have made the representation. They have received it.
That was clarified. They could have.
I have not given to the Reserve Bank of India if you are saying that. The Reserve Bank of India ought to have been sent to the
This representation was not made to the sanctioning branch, my lord.
Sanctioning branch means?
So it was never, it could not, the loan was sanctioned from the.
Who sanctioned the loan?
Yes, my lord, I'll just indicate the branch with which it was sanctioned.
Authorized signatory Axis Bank Holdings, Shankar Pukur Plot, Bardhaman, so GT Road, Tripoli.
No, it was sanctioned
Bardhaman.
from another branch, my lord. I'll just.
Bardhaman.
Yes, my lord.
Bardhaman, yes.
No.
Respond number, my lord, page 29, 3.
No, it is sanctioned through, my lord.
Yes, what is your
My lord, my submission, humble submission, my lord, initially when the page 26 was placed, we were agreeable to that. We have obtained the loan, admittedly, and they cannot deny it that till today we are not paying. We are paying. That is not the issue. I have made the representation before the authority for certain relaxation so that we can meet the demand in a proper manner. We can repay or repay.
Once you have agreed and payment has been made, how you can?
My lord, that is at page 26. In respect to the page 26, my lord, we are agreeable.
26 is
now they are saying that is an error. I am admitting that.
26 they are taken as a monthly.
Yes.
Not the quarterly.
Quarterly, because
if 8,325 is taken into the quarterly into 3, 8 3s are 24,
Yes,
and 3 3 are 9, so automatically 26.
Automatically it is come to 26. Now, my lord, the issue remains. My lord, let there be a proper breakup if you can meet in a proper manner, my lord. Because, my lord, the issue, let them consider this thing.
Why all these things are it can be entertained? You go.
Because, my lord, the authority, we have made the representation. Let them consider it at least. That is subject to your lordship.
The petitioner has filed the present date application.
I am great. My lord, subject to your lordship.
Yes.
May I leave, my lord, subject?
Yes. Praying for a direct upon the respondent number 7. To consider the representation of the petitioner for adjustment of the installment of the bank loan. The petitioner submit that the petitioner initially has obtained loan from 9,40,000, but subsequently the petitioner could not proceed with the said sanction of the said loan, and subsequently 6th March 2025, the bank has sanctioned loan in amount of 7,40,000. The said loan, the installment is the return of the term of loan is for 84 months. That is limited expiry date is 6th of March 2032. And the payment of loan is as quarterly basis. That's what the counsel for the petition submitted. At the time of sanction of the loan, the bank has given the schedule what would be the principal amount and what is the interest required to be paid by the petitioner. He submits that as per the schedule, the principal amount would be rupees 26,429 and interest would be rupees 8,325. Total amounting to rupees 34,754. By calculating the interest at the rate of 14.62%. He submits that all of a sudden, the bank has issued the revised schedule of repayment of the loan on 20th March 2025. by increasing the interest from rupees 8,325 to 26,000. 26,000. And accordingly, the petitioner has made a representation to the authority, but the representation has not been considered. And still the representation is pending. And a counsel for the respondent bank has submitted that the after the loan of rupees 7,40,000 is sanctioned, the schedule is given to the petitioner by intimating the interest at the rate interest at rupees 8,325, that is per month. But the loan was sanctioned, but the petitioner has to pay the loan amount quarterly. And as such, when the respondent bank has realized the mistake, immediately the same has been rectified and revised schedule has been provided to the petitioner. He submitted the petitioner and the bank has not increased any rate of interest. Only the petitioner and the bank has informed the petitioner that earlier the interest rate has been shown as per month, but subsequently it has been shown as quarterly. He further submitted the writ petition filed by the petitioner is not maintainable, as this is the purely a contractual dispute between the petitioner and the respondent bank. And as such, the writ petition is liable to be dismissed. Had the learned counsel for the respective parties peruse the materials on record. This court finds that initially the bank has given this schedule for repayment of the loan, in which the interest is mentioned as 8.325, 8,325 rupees, rupees 8.325. But the said interest is per month, not quarterly. The loan sanctioned by the bank authority is for quarterly. The petitioner has to pay the loan not by month, it is to be paid quarterly. And as such, when the bank has realized that mistake has been happened, accordingly revised schedule has been provided to the petitioner, intimating that the quarterly interest of the loan amount would be rupees 26,000. Considering the above, this court find that there is nothing in the find that there is no, and the respondent bank has not committed any wrong. Thus, no further order can be passed. Accordingly, writ petition is dismissed. Next.
16 also similar matter, my lord. The loan amount is just different, my lord.
Same loan.
Yes, my lord. Loan amount is
Amount is different, 9,80,000, my lord. Similar error happened in that.
sanction letter is on page 12, my lord, and the annexure is page 18 and page 19. The later
Khali loan amount 9,80,000.
Yes, my lord.
Loan amount 9,80,000. Okay. And interest schedule
page 18, my lord.
11,025. But subsequently
Thereafter,
it
page
paid
90.
as interest quarterly of rupees 35,000.
Come to the same interest, my lord, 13.5%.
9 lakh same. 9,80,000. Disposal. Next.
17 Lordship, I am for the petition.
Pursuant to last date's order, we are
There
filing
is
our
application for new electricity
report
connection. There is
after
direction,
inspection.
file and report by the CSU authority, Lordship.
But we are agreeable to give him a loop meter. Subject to legal compliances, we are agreeable
So
to.
we are ready to comply with the
A separate house in the plot jointly shared. Yes.
Lordship, we are ready to comply with all the formalities.
The petitioner has filed the present writ application, praying for a direction upon the respondents to provide new electric connection in the premises of the petitioner. This court has called for the report from the respondents
CESC, Lordship.
from the CESC Limited, and accordingly the senior engineer Southwest District CSC has submitted the report wherein it reveals that the petitioner has a separate house in a plot jointly shared with the brothers and sister. The CSC had provided 4 meters in favor of the family members of the petitioners earlier. Earlier, the petitioner used to get supply from his own meter, being consumer number 09150255007, which was disconnected on 17th of January 2001 for non-payment of the outstanding bill. Now the authorities submit that the petitioner had a loop meter supply. Accordingly, the respondents are ready and willing to provide a loop meter in favor of the petitioner, subject to payment of necessary charges and compliance. The petitioner submitted he will comply with all the provisions and will pay the necessary charges to the electric for grant of electric connection. In view of the above, who is the authority?
Lordship, the district engineer of the
Respondent
CSC.
number 2.
Respondent number
Directed
2.
to provide the new electric loop meter.
Loop meter.
From the existing meter board position.
New meter in the existing common meter board position in the premises of the petitioner within a period of 4 weeks, 2 weeks,
3 weeks,
within a period of 3 weeks from the date of compliance of all formalities by the petitioner.
Lordship.
WPS disport.
Grateful, Lordship.
Report be kept with the record.
Yes, my lord. With regard to the item number 18 and 19, my lord, both the issues, my lord, are similar in nature. My lord, though the affidavit of services, my lord, it requires affidavit. My lord, there is no scope for interim order. I cannot say. Admittedly, it requires, my lord,
Mr. Caldwell was on view of the private respondents. I am paying for short pass over.
Affidavit to আমি তো interim order. I am not pressing for interim order.
Okay, ঠিক আছে.
What is the prayer?
My lord, prayer is, my lord, that the cancellation of the order passed by the registrar of the death and birth, my lord, that the husband expired, my name was there, that was deleted, as well as at the instance of the complaint of the private respondent, my lord, my name from the electoral roll also gone.
P8.
My lord.
Where is the P8?
My lord, here, my lord, P7. My lord will get at P7. Yes, my lord, that is at page
But in your prayer,
39.
39.
39, my lord.
29th May. This is a P7.
P7, yes, my lord. Page 38, P7, and 39 is the next one.
P7.
P7.
But kindly come to the prayer portion. P8.
P8. My lord, that is my lord, typographical error.
Regarding petition of the
because I cannot say that it has to be stated. There has to
Appearance
be.
of respondent number 1 is necessary, Your Lordship, because
Yes,
the order was
appearing.
passed by the
My lord, I have
officer.
served. My lord, the authority has been served.
number 1. District election officer.
Yes, my lord, I have been. It has been served. My lord, there is an affidavit of service to that effect, my lord.
In item number 19, I am happy to want with the state respondent.
18.
18 and 19, my lord, both are same.
But
But 18, item number 18, much lordship, that respondent number 1 is present necessary because
District
there,
Election Commission.
yes, lordship,
My lord,
because
we have-
the
it has
order was
been
passed
served.
by this
It has been served.
authority, much lordship.
Yes.
Without the authority, much lordship.
For such reason, I have prayed that there is no scope for interim order. There has to be an
It is
evidence.
delivered 21st of August 2025.
Lordship.
But
Now it
probably
is-
that time the honorable it has a
Who is
different.
appearing?
I don't know. So I am appearing only for the private respondent, much lordship.
You are not appearing in the 18.
No.
I have served. No, let there be an affidavit to that effect.
If the other party will come, it can be disposed of. Why affidavit? Why it is come in the?
Because, my lord, if I press for the time being that the page 38, if your lordship kindly sees.
Yes.
My lord, this is to inform you that as per provision of the registration of birth and death, so and so, in case of domicile death of Panchayat area, the sub-register of the birth, death and Mogra Gram Panchayat, in case sole authority to issue the death certificate. As the registration of the death was done at their end as mentioned above. Hence, the death certificate of Devashish Pan, that is my husband, issued by the then registrar, so and so, dated so and so, which was not in our jurisdiction, may be considered invalid as per modalities mentioned by the provisions of the register of the act so and so, and the so and so, the certificate issued by the sub register on the first December 20.
Yes, Miller, for the contesting respondent, but the election commission is also a necessary party.
Miller, I have served.
Yes, but question is, Miller, the factum of marriage is one thing that is for the civil court to decide, and based on such fact, if the claim generates or emanates from the factum of marriage, then Miller, other question possibly becomes unnecessary at this juncture, because we are denying Miller the existence of marriage.
Yes.
That is my instruction. Number one. Number two, the order, Miller, as that has been passed by the Miller, the issuance of the death register under the specific act, that has also been questioned, because the authority concerned who had issued, he had no
Not the
jurisdiction.
jurisdiction.
So Miller, he has to satisfy first that the gentleman who had issued Miller, that is absolutely as per law, and the reasons assigned by the authority, Miller, is contrary to law.
Correct.
If the prima facie case has not been made out, the interdiction of this honorable court at this juncture may not be warranted. That is my respectful submission.
Yes.
May I submit, Milord? Milord, the issue, Milord, initially, Milord, if your lordship kindly sees the page.
Who is she? She is claiming to be as a wife of the deceased.
Deceased.
Devashish Pan. Correct.
My lord. Now, Milord, kindly come to the page 31.
Page 31.
Yes.
Yes.
Page 30. And page 31st. Page 30.
Election Commission of India.
Yes. Milord, here the name Alpana Chakraborty, Hamid Nam, next part. Milord, the name of the husband, Devashish Pan.
Yes.
And this thing was issued, downloaded on 18th January 2025.
Correct.
And in the electoral roll, it was available.
Correct.
Now the question of marriage. I have annexed the photographs.
Can this court decide that?
No, I am not on that. Of what I am on, page 30, Milord, page 30 was questioned by the private respondent.
I'm sorry for the unwanted interruption. My learned friend Milord has not been properly instructed, because the judicial order says on 14th May 2025, this is an interim stage. However, Milord, in a proceeding, Milord, under section 23 of the Milord PWDV Act, which says, Milord, this is an interim stage. However, regardless of the facts as they are otherwise stand, it is clear from the averments made in such and such wife of the respondent that at present the petitioner is unable to peacefully stay at her matrimonial home. However, there is a peculiar case as a fact of marriage has not been duly established, and it also appears that a single document has been furnished to prove that the petitioner had ever been lawfully married to Devashish. So, Milord, if this finding has been upset, Milord, the question today, Milord, it is more sentimental than legal, Milord.
Now, Milord, the issue remains, Milord, just now, Milord, my learned friend has submitted this thing.
Who is for the private respondent?
I am for the private. So he's my junior.
Now,
file affidavit and question of.
yes, that I have submitted in a
File affidavit.
yes.
Respondents are directed to file affidavit in opposition within 3 weeks.
Yes,
3 weeks. Reply if any that is
89
thereafter. List the matter.
তুমি ওটা এফিডেভিট না দিলে তো আমি রিপ্লাইটা দিতে পারছি না।
পাচ্ছিস না তো। আমি তো reply 1 weeks না।
দাও না দেখি না
6th of January.
কোথায় কি আছে?
Yes, next.
My lord, 19 is the same and identical.
19 same.
Issue.
Next. Huh? Next.
Affidavit of service. May it please your lordship.
Yes.
Lord, I have served all of them. The affidavit of service is there. And I have given fresh notice also. My lord, the facts are short, my lord. The petitioner number 1, husband is 80 years and his wife is 73 years. The private respondent is the youngest son. And because of his behavior, etc., the petitioners have had to leave their hearth and home and stay elsewhere with their family of the daughter, married daughter. We made a complaint before the tribunal. A comprehensive representation, which is in Bengali, my lord, therefore I will not place it. But my lord, the tribunal, after 1.5 months, calls us and passes an order, my lord, without taking care of the situation that is prevailing. Lordship will just see the order, which is under section 24. Annexure, my lord, P4 at page 74.
Yes.
Petitioners and OP both are present. Heard them. Petitioner stated that his younger son, OP herein, torturing physically and mentally both his parents as well as his elder brothers and sisters. They also stated that they are now living at their daughter-in-law's house on and from 2/3/2025. They only want to live peacefully their own house. OP stated that he is 90% physically handicapped, and in this physical condition, he can't torture his parents either physically or mentally. This is wrong, my lord. I'll show you, lordship. He also said that due to his physical condition, his parents, along with his siblings, harassed him few times by many ways. Therefore, the undersigned, being the prescribed authority of Maintenance Tribunal, hereby ordered under Maintenance and Welfare of Parents and Senior Citizens Act, but both parties will maintain peace in their house after considering all the submitted documents and after affording reasonable opportunity of being heard to all the interested parties. Officer in charge, Bangor Police Station, is directed to arrange to send adequate police personnel during taking over possession by the petitioners of our own house to avoid any untoward incident. He is also directed to ensure no physical or mental harm is caused to either Mohar Ali Mullah or Saleha Khatun, the petitioners herein. The concerned officer in charge is also directed to take an initiative to regain peace in the family by assisting them. Now, my lord, we send a letter, which is page 75.
Yes.
Now, my lord, page 75, lordship kindly comes to the relevant portion. Paragraph 2, my lord, of the 75. Notice dated 26/25, after a fortnight from the date of complaints, in spite of grave urgency of the matter and chances of life risk of the complainants, was issued on the said complaint to both the complainants and the perpetrator's son. On 10/7, the proceeding was conducted when my clients were heard and the perpetrator's son was also heard. At the time of hearing, my clients felt that the grievances would be taken care of by orders to be passed in the said proceeding. The facts stated are so and so. On 13/7, 3 days after the date of hearing, my clients had to make a complaint once against to you that the perpetrator's son had, in furtherance of his illegal activities, complained of, and with intent to show that he was least bothered with the said proceeding on the complaint of my clients, proceeded to till the land of the complainant number 1 with tractor, and also proceeded to threaten both my clients and the lessees of the land of my client number 1, for which my client number 1 had to address a letter dated 13/7 stating the said facts and requesting for protection. On 14/7, when so-and-so son-in-law of my clients went to the office, he was handed over a copy of the order dated 10/7. My lord, the entire proceeding has been disposed of, and we write, my lord, on a perusal of the said order passed by the learned maintenance tribunal, my clients were surprised to find that the order passed had disposed of the proceedings without taking care of the situation and or granting appropriate protection, particularly when there was grave apprehension of physical harm, even death in the hands of the perpetrator son. That it would be therefore evident that the grievance of my clients had not been taken care of. And Lord, next page, your lordship sees what facts we have placed, Lord. Page 77, Lord. Based on 10/7, disposing of the said proceeding suffers from infirmities inter alia as follows. The claims of the petitioner as reflected in the order dated 10/7 are completely false. He has claimed that he is 90% physically handicapped. It is not possible for him to mentally torture his parents. But in reality, despite having a slight eye problem, he does his daily activities without any helper, and he has a two-wheeler which he drives himself. He claims that due to his physical condition, his parents along with his siblings harassed him few times in many ways, which is a false statement. There is no order direction for investigation in this regard. My lord, the maintenance tribunal should have at least directed appropriate investigation by the police and given me protection, my lord. It doesn't do so, it disposes of. My prayer, my lord, subject to lordship's pleasure, my lord. Lordship kindly comes to my prayers, my lord. To make it short, my lord, I don't want to trouble your lordship unnecessarily. Lordship kindly comes to the prayers at page 21.
Yes.
Upon modifying the order dated 10/7 passed by the respondent number 2 and file reports before this honorable court for passing further and necessary orders to protect the life and liberty of the petitioners. My lord, if a report comes, your lordship will ascertain, because they will be forced to file something based on their investigation.
Yes.
And my lord, see, my lord, directing the police authorities to protect the life and liberty of the petitioners by taking police action against the private respondent. Because, my lord, I have not been able to return to my house till today.
So you are in, where are you now?
Son-in-law's place.
Not in the said house. Not in the said house.
No. I couldn't go back also.
Yes.
I am appearing on behalf of State Respondent Lordship. This is the copy of the police report, Lordship. Kindly see. There is only GD file in this respect of this incident, and
No, that is correct. But how your authority can pass an order in a single page
Lordship,
without calling a report from the
I'm grateful.
there is the provisions of appeal, Lordship, in
but if this court find that the order itself is wrong, without giving a without calling the where is the report? Authority has to do as per the procedure. He has to adopt all the procedure.
Lordship, petitioner can go into the appeal before the appellate authority as per the provisions stated in maintenance and welfare parents.
Correct. 23.
Yes, Lordship.
19 or 23? 19.
16, Lordship.
16 or 19?
16, like
16. Yes, 16. But here, if your authority has not followed the procedure, singly if you receive the complaint and pass the order, he stated that he is a handicap. Whether he has ascertained whether he is a
It is held that the OP stated that he is 90% physically handicapped.
correct. How he came to know?
If he can drive the vehicle, etc.
Once you hold
Lordship, then kindly give some time so that I can get the
what I am proposed to do, what I am proposing to do, I am setting aside this order, demanding the matter back to the authority to consider a fresh, be giving an opportunity of hearing all the parties to call for the report from the concerned authorities, including police authority, and pass a reason order.
Grateful, Lordship. Grateful.
Gotcha.
Very well, Lordship.
Correct.
And my lord's protection in the meantime, my lord, so that I can go back.
You make a prayer. I will clear. If you make any application, he will consider the interim prayer.
Look, they have given that prayer. They have allowed that prayer, but my lord, no effect.
That if it not, then we'll see to
Or in the alternate, my lord, would it be your lordship's pleasure to ask for a report from them and consider the matter after a fortnight? subject to my lord's pleasure. I know your lordship is pressurized like anything, but then I feel, my lordship will protect me properly, my lord. Otherwise, they will not do it. The first day they dispose of the matter, my lord.
So that's why I'm telling, I will can't call for the reports from the concerned authorities, including.
My lord, investigation first, investigation thereafter.
No, investigation of the, because see, here he has to call for the report from the BLO and from the police authority and to here and the petition.
Lordship, I'm grateful.
The other party was taking the benefit of the 90%. He has to ascertain whether he is suffering from 90% or whether the report will come.
Lordship.
The petitioner has filed the present application challenging the order passed by. Where is the impugned order?
My lord, impugned order is at page 74, annexure P4.
The learned.
And my lord, the Women's Commission has not acted at all.
Passed by the learned sub-divisional officer, Baraipur, South 24 Pargana, and Chairman Maintenance Tribunal, dated 10th July 2025. The ground of challenging the said order, that in the order, the learned sub-divisional officer has come to a finding that the OP is a is 90% physically handicapped. And the sub-divisional officer also directed the parties to maintain peace in their house after considering all the submitted documents and after affording reasonable opportunity of being heard to all the interested parties. The learned magistrate has not described what are the documents available with this learned magistrate at the time of consideration of the case. Whether the document relied by the sub-divisional magistrate at the time of passing the impugned order, an opportunity is given to the petitioners to consider the document, and if any objection, the petitioner will get any opportunity to file any objection to the said document. This court also finds that before passing the impugned order dated 10th of July 2025, no report has been called either from the BLO or from the police authority. Considering the above, this court finds that the order passed by the sub-divisional officer is not in accordance with law. According, the same is set aside and paused, full stop. The matter is remanded back to the sub-divisional officer Baraipur South 24 Pargana and the Chairman Maintenance Tribunal to consider. Where is your complaint?
My lord, complaint is at annexure P1.
What is the date?
My lord, dated,
my lord, by the petitioner dated 13th June
13/6/2025.
13 June 2025 afresh, after giving an opportunity of hearing to all the parties and after calling for the report from the sub-divisional officer, from the BLO as well as the police authority. Full stop. If the sub-divisional officer is relying upon any report and the documents before passing any order, the said documents and the report be supplied to the petitioner so that the petitioner can take appropriate steps if the petitioner agreed with any report. The sub-divisional officer is directed to complete the proceeding and pass a reasoned speaking order within a period of.
Yes, Lordship.
How much time? 8 weeks? 6 weeks?
8 weeks, Lordship. 8 weeks.
8 weeks from the date of receipt of this order. Police. It is made clear that if the petitioner will file or pray before the sub-divisional officer for any interim relief, the sub-divisional officer shall consider and pass appropriate order in its own merit.
But only one sentence.
By taking into consideration of the old age of the petitioners.
Milord, one only, Milord, 13/6 and further complaint dated 13/7.
13/6 and further complaint dated 13 July 2020.
I'm grateful.
Grateful, Lordship.
I'm very grateful.
Yes, next.
It's a very serious matter, but appointment of judges in the administrative tribunal. They are supposed to file a report.
Who is ready to go to the administrative tribunal?
But all the way today I can say that I have undertaken to Mr. Banerjee that I'll not take much time.
You are not the consented person to be appointed.
That file is lying with the governor, blood. But in terms of new act, new rules, blood, this to be sent to the blood Union government.
Since when the post is lying vacant?
My lord, since
The tribunal is not working. State administrative tribunal said.
There is no even administrative member. Blood, last two reports, blood, if you kindly have a look, blood.
Who is the authority?
My lord, the state government, my lord, I am appearing for the High Court administration. My lord, we have submitted a
High Court
report.
administration. Have you
A search and selection committee, my lord, was constituted, headed by
who is
the
for the
Honorable-
state?
My lord, Mr. Basu Mollik was appearing for the state and he had submitted a report saying that, my lord, the recommendation is pending for consideration before the Honorable Governor. And he was to
If I'm
come
asking
back.
Who is for the state? Then I will call for the report. Let the report come from the office of the governor if it is pending. Since how long it is pending before the governor?
My lord, a new development has come, my lord. Supreme Court on 19th of November, my lord, few days back, my lord, has declared this Tribunal Reforms Act ultra vires. My lord, there was a direction that whatever.
4 weeks time is given to complete all the proceeding, appoint the persons.
My lord.
Then
So they need to, my lord, expedite. The state needs to expedite. Otherwise, my lord, it will be a very complicated.
that's I'm telling. So what steps have been taken after the order of the Supreme Court?
But they have to. There is no other alternative.
Who is for the state? Who is
Mr.
appearing normally in the
But,
matter?
Mr. Basu Mollik was appearing, but possibly he is not appearing. But Amrita Paja is a AOR. She must be there, blood. If you actually look to the last order, blood, there was a direction on 22nd September 2025. Let a further reminder be made to the Governor's Secretariat for providing a response to the proposal forwarded by the committee. Paragraph 4. Blood.
But the reminder gone, and that's why who is appearing for the state? That is required. For the governor, any other.
Blood, may I inform the GP, blood?
Correct.
Can you pass an order, blood, so that I can.
Kindly fix the matter at your lordship's convenience so that we can get back, my lord.
This court find that the matter is to be heard in presence of. This court find that the report from the state required. Full stop. By an order dated 22nd September 2025, this court has issued a further reminder, has directed to issue a further reminder to the Governor's Secretariat for providing response to the proposal forwarded by the committee. But no report is before this court. Accordingly, the petition is directed to notify the next date of hearing to the government pleader. And the state is directed to file a report with regard to the status for appointment of the chairman.
All. The total number is one chairman, 2 judicial member, and 3 administrative member.
For appointment of what is your prayer? For appointment of administrative member and the judicial members.
Chairman, 1 chairman,
judicial member,
2 judicial member, and 3 administrative member
of the state administrative tribunal, West Bengal.
Friday.
Let the matter appear on 2nd
December.
Under the same heading.
Instead of 2nd, any other day, First
is the monthly list. You will.
Oh, 3rd.
Next.
I'm taking to him that I'll not take much time.
No, but I cannot spoil the honorable court's time because this residuary is very, very busy. Most of the senior judges, my lord knows, my lord used to visit Calcutta of senior judges. Senior judges of Calcutta, they used to take. It's very correct. No, my lord, very small point. Small tender value, big problem. And where the big tender value, small problem because money talks. Now here, my lord, what is actually happened? Big tender value.
Who is for the state? Have you issued notice? Where is the affidavit?
Where is service going? দেখো তো ভাই কি করা হলো? ও না ঠিক আছে দেখেন
Yes.
only three or four paragraphs I'll place to your lordship for your satisfaction. Please kindly come to page 4, para 10. Everybody got it, my lord?
Yes.
Yes. Your petitioner states that no specific guidelines or method statement or construction was provided by the respondent to the petitioner, but was advised to follow the conventional method of the construction of the vertical extension at library building of the Calcutta College. Accordingly, the petitioner commenced construction work under the close supervision of the junior engineer working under the respondent 2 and other subordinates. Your petitioner states that it had been taken steps to execute the contractual work and that deployed necessary infrastructural facilities and plant and machinery. These plant and machinery, my lord, the big contractor like Aluwalia from Delhi, they have got their own machineries. But here very small amount, small contractors. They normally hired all these machineries.
How the small contractor engage you, sir?
My lord?
How the small contractor engage you?
In addition, the petitioner had also procured sufficient and adequate quantities of construction materials of approved qualities such as reinforcement steel, cement, stone chips, sand, construction as per the specification of the item of work as provided in the description of item being part of the work order. Your petitioner had also deployed both skilled and unskilled workmen as well as supervisors for the construction work. Both the steel materials and the cement which the petitioner has procured were from the authorized agent and were tested by the test of quality. Your petitioner further state that before using the said materials, the petitioner had shown the rest test certificate to the respondent 3 and other supervising engineer working under the respondent number 2, copies of such and such. Your petitioner states that the work with the scope of the contract principally involve RCC work for column, beam and roof, brickwork on walls and other finishing works, and the said work was executed as per the drawing provided by the department. Every stage of progress of the work was supervised by the respondent 3 and other supervising engineer working under respondent 2. No adverse comment or observation was ever made by any of the supervising engineer, and the petitioner proceed to such. Well, this is really something funny after some times when virtually construction the verge of completions, my lord. And I have not yet received money till today. Then my lord kindly, they stop. They say, no, something wrong somewhere. Very well, let me know what is wrong. Kindly come to para 17 and 18. Paragraph 17, my lord, page.
Yes.
Your petitioner states that certainly after casting of the roof on July 4, 2025, a verbal instruction was received from the respondent 4, the subdivision officer, for stopping or further work at the post roof casting stage. Such instruction was not feasible to be adhered to due to the technical constraint, since it was essentially required to spread cement water, in Bengali what is called ghola, on the rooftop to protect the rooftop. It was also necessary to keep the rooftop wet with water for such and such. Thereafter, a team comprising of respondent 2, the block development officer, the district engineer, the Purto Karmadakko and others engineers visited the work site in the afternoon on July 5, 2025, who inspected the rooftop after complete casting of the roof. After such inspection, the respondent number 2, the executive officer and the block development officer, in presence of the district engineer, instructed your petitioner to continue to apply cement gola on the rooftop as per technical requirement and also to keep the rooftop wet with water. No observation, adverse or otherwise, however, was made by any of the respondent with regard to the casting of the roof or installation. It was reasonably believed by the petitioner the issue, if any, with regard to stoppage of work was demand to have been closed. This visit and inspection of the dimensions. So, my lord, after that, they asked me to stop the work. I say, what is the basis? First thing, you did not pay me single farthing. Secondly, all certificate was issued to you, so to you. You accepted that. I more or less completed the construction. Now, in the verge of completion, you are coming. No, I want to inspect. You inspect, I don't mind. But the problem is this, my lord, the certain others, which I have already hired from other party. It is
to pay the
But I'll have to return that. And kindly come to one page 27, page 11, last paragraph, paragraph 27. Have you also got it, my lord? Under such circumstances, the petitioner had written a letter to the respondent to the executive officers and such, internally are requesting for drawing the RA bill for the work done till date and releasing payment against the same, allowing the petitioner to remove the shuttering materials since the entire curing period 28 days is already over from the date of casting, since rent of the shuttering materials has been accumulating, allowing the petitioner to start the work and to complete the residual work for the project without any further loss of time. Nothing has been done.
Yes. What can with the other side?
We have
What you
sub.
prayed for? What you have prayed for?
My lord, I pay, my lord, first thing, my lord, I may be allowed to remove all the shuttering. And secondly, what about my payment? And they must allow me to complete. If they have got any objection, tell me frankly, this is the problem. My lord, kindly see, I have annexed all the document, all documents are annexed. And after being satisfied, they allow me to continue.
So who is the authority? Subdivisional engineer.
Gorveda Panchayat Samiti, but what is authority? You are under the executive engineer, officer, executive officer.
Block development state government, junior engineer subdivision. You have not made a party. Who has issued the tender? Who has stopped?
Party calling me again? As I am told, all of them have been made as a party.
Subdivisional officer for stopping.
Subdivisional magistrate, the junior engineer.
So let the 3 and 4 submit the report before this court.
Yes, I don't mind. My lord, kindly come to page 82, my lord. Because had it been a case that well, I didn't supply any certificate, and the Capstan Steel India Limited, that is one of the best company. From them I purchase it. Then my lord, kindly take trouble to another. This is the costing, page 100. My lord, page 82, the receipt and everything. Captain Steel, page 82. Have you got it, my lord?
Yes, got it.
My lord. Then kindly come to page 100. This is the construction which is going on, and I did it.
Nobody is appearing. I am directing to submit a short report by 3rd.
As well as my.
Let the matter appear on 3rd. Let the report come. If they will not come, then appropriate order.
I get you.
The petitioner has filed the presented application being agreed with the verbal or instruction issued by the subdivisional officer for stopping the further work at the post roof casting stage.
Third term, executive engineer, block development officer.
But you have not made a party. Where is the party?
Development officer. He is a party.
Block development officer. Block
Question number 1.
Subdivisional magistrate and subdivisional office capable. Post roof casting stage. Full stop. The petitioner submitted that no reason has been given why the work has been stopped. It is the specific case of the petitioner that no specific guidelines or method statement for construction was provided by the respondent to the petitioner, but was advised to follow the conventional method of construction of the vertical extension and library building of Garbetta College. He submits that the petitioner has taken appropriate steps to execute the said work and had deployed necessary infrastructural facilities, including the plant and machinery. He further submits that the materials which has been used by the petitioner that was used with the supervision of the engineers and after obtaining the test report. Though the as none appears on behalf of the state authorities, accordingly this court is of the view the report is necessary to pass further order. Accordingly, the respondent number 2, respondent number 2 is directed to file a report, a detailed report by way of an affidavit. After serving the copy to the learned counsel for the petitioner on or before 2nd of December 2025, let the matter appear on 3rd December 2025 under the same heading.
I'm grateful, deeply obliged.
The petitioner is directed to communicate this order to all
Yes,
the
certainly.
respondents and to file affidavit of service on the next day.
Absolutely correct. I'll do that. Tomorrow I'll come at 12 o'clock. That's the thing. Why not? That I'll take some. I'm grateful. May I leave, my lord? Thank you.
But I have for the petition, my lord.
Lordship,
My lord, a video service is there. My lord, kindly come at page 4, paragraph 5 and 6.
Lordship, I'm led by learned additional Solicitor General. Lordship. Lordship, we don't have received the instruction yet. Kindly.
What is the prayer? Passport?
Passport, my lord, for my minor son and daughter, my lord.
Yes.
We don't have.
A reprint is also given, my lord.
Lordship, we don't have received the instructions yet. Kindly adjourn matter for a week. Will be able.
When ASG will appear?
Lordship, he couldn't come.
On behalf of the police authority state, I am appearing for the state respondent, your lordship, respondent number 4. I have received instruction to the extent that regarding the verification of passport of the daughter, it is pending before the regional passport officer. And regarding the passport of the minor son, we have sent a mail to the concerned municipality. They have
Municipality for what?
Yes, your lordship.
For municipality for what?
Regarding the date of birth and birth certificate.
Verification of, okay.
But they have informed that it was not issued from them. It is a fake document. They have informed and we have annexed in our instruction. I'm handing over one copy of my instruction, lordship. All the annexures are there, including my report on behalf of the officer in charge. Paragraph 3 and 4 of my report, first page. The relevant portion.
না না বার্থ সার্টিফিকেট ফেক আছে তো কালকে আমি ধরলাম না তোর সামনে সেই হয়ে গেল আমাদের নামগুলো দিয়ে
The last annexure, your lordship, from the Pujali municipality, annexure E. Verification report of birth certificate of Ithan Dotto. As per later dated such and such, it is to inform you that the birth certificate of Ithan Dotto, son of such and such, certificate number such and such, registration number such and such is unauthentic and it was not issued from our municipality, municipal birth register.
Issued by the Pujali municipality.
Yes, birth certificate was issued from Pujali municipality and the discharge certificate from the hospital that is within Kolkata, your lordship. This anomaly was also there. Kindly see, it is stated in paragraph number, second page, second para. Second para, your lordship. As per discharge certificate, it could be learned that petitioner's minor son Ithan Dotto was born on 27/11/2019 at Avinash Dotto Maternity Home, that is lordship within BK Paul Avenue, Kolkata 70005. And as per birth certificate, it could be learned that birth certificate of petitioner's minor son Ithan Dotto was issued by Pujali municipality, district South 20.
Okay, you do one thing. You serve the copy to the others.
Yes, sir, lordship.
And you go through, and if you want to file the exception, you file the exception. And when you will appear, when you take instruction.
We will need 1 week, lordship.
1 week is the passport.
Lordship, the passport authority kindly gives the matter any day other than the Monday.
other than Monday, my lord.
the
Awake করছে তো।
state respondent has filed report after
Let's go.
serving the copy to the learned counsel for the petitioner.
আমি
The
বললাম
counsel for the petitioner is at liberty to take exception if any,
এটা এখানে কালকে দৈত্য
if any within a week from
করছে,
it.
চিৎকার করছে।
The counsel for the appearing for whom? Passport authority. Appearing for the Union of India and passport, regional passport officer. Prayed for 1, 2 and 3. 1, 2 and 3. Prayed for time to take instruction. Accordingly, case is adjourned. Let the matter appear on 9th December.
9th? Mile.
9th December.
9th.
Under the same heading.
9th December, ma'am.
Under the same heading, affidavit we kept with the report, affidavit service.
Well,
Yes, next.
this is my application, my lord. The unfortunate couple, my lord, is the petitioner before your lordship, and having, my lord, failed to conceive a child, my lord, they decided to take, my lord, assistance of the, my lord, assisted reproductive technology covered by a act, my lord, IVF clinics. They went to IVF clinic. Treatment started, but after some time, my lord, they have given an endorsement that we cannot continue with the treatment unless you take High Court permission. Reason being cited is, my lord, Section 21G of the ARS Act, which says, my lord, that service can be provided to a female up to the age of 45 and a male up to the age of 55. Now, the wife, my lord, petitioner number 2 is within the age, but the husband, my lord, has just crossed 55. This is the position, my lord. Now, kindly allow me, my lord, to produce side these provisions.
Sabir Ali is the husband.
Yes, he's the husband. He has crossed 55. Lordship kindly takes the act, my lord. Lordship will take note the second act, Assisted
21G.
Reproductive Technology Act, 21G. Assisted, not Surrogacy Act. That is surrogacy.
No.
ART Act, Assisted
ART,
Reproductive
This is
Technology Act. No, it contains the,
contains
the
that.
second statute, my lord.
Yes.
Lordship will kindly come to Section 21G, my lord.
The clinic shall
The
apply
clinic shall apply the assisted
reproductive
technology services to a woman above the age of 21 years, below the age of 50 years, and to a man above the age of 21 years and below the age of 55 years. And this has to be read with Section 27, subsection 2A.
27.
27. Why I say, my lord? Because in this case, my lord, the, my lord, sperm is to be collected from a third party, because, my lord, this, since the person has exceeded the age of 55 years, my lord, we admit the position. So 27A comes, my lord, it has to be a sperm bank. The bank shall, kindly come to 2, my lord. The banks shall obtain semen from males between 21 years of age and 55 years of age, both inclusive.
Just like
This
blood.
is applicable. So, my lord, like blood donation, my lord. So, my lord, in this case, my lord, there is no active participation of the male member.
Obtain semen from male
Male.
between 21 years and 55
55
years of
years.
age, both inclusive.
Both inclusive. Now, in this case, my lord, since the man has crossed 55 years, my lord, he cannot provide the semen. It has to be collected from a sperm bank. In that view, my lord, the now 21G, kindly read 21G. So, in view of this, my lord, the man has no role in the system, in the services, since the man is not providing the sperm, he has no role in the services. Only the female who is within the age is the person who is not getting the services from the sperm bank.
Even the 55, but the husband's consent is not required.
Yes, they have gone. They have both of them have both of them.
Consent is there.
Consent is there. They have approached, my lord. They are both of them are petitioners. Both of them are before your lordship,
Correct.
my lord. Now this is the position. Now, my lord, this exactly similar situation has been considered by this honorable court in the coordinate bench. No. Hold on. Here, my lord, the same thing happened. The husband crossed the age, wife was within the age. Lordship will see from paragraph 13 onwards, my lord. The court has held, reading these two sections, that there's no role of the husband in the entire system, entire process. Then 21G cannot be 13 onwards, my lord. Exactly similar to our case. May I read? ওটাকে রিলাই করেন সেপারেট পয়েন্ট আনরিপোর্টেড কপি আছে স্যার দেখি প্যারাগ্রাফ 13
রিপোর্টটা কনফার্ম করে নেব না লেডিস এটা না বলে
না লেডিস ফিট এখানে ডকুমেন্ট আছে
না ওনার রিপোর্ট কনফার্ম করেছিল বেশ
they are medically fit
ওদের সার্ভিস করা হয়েছে না
হ্যাঁ সব এভিডেন্ট সার্ভিস দিয়ে দিয়েছে
Yes.
medically
Now, in this case, my lord, the court has held that since there is no participation of the male member, my lord, it can be applied. 21G shall not be a bar. Although we have challenged.
What about the report of the lady?
Now, my lord, the IVF clinic doesn't say, my lord, that the lady is incapable of, my lord, availing the services. It only says you take permission and they cite the ground of 21G.
Where is that?
Page 24. Although 21G is not mentioned, my lord. 24, the prescription at the bottom, your lordship will see, my lord.
court ART board
Need High Court or ART board permission for IVF. Needs High Court stroke ART board permission for IVF.
there is a board under the ART Act.
The same thing happened in that case also, my lord. The clinic refused by saying that unless.
My submission, your lordship kindly schedules my lord, at page, my lord, 17. Yes, prayer B, my lord, my learned friend has challenged my vairies of the.
We shall not press. We shall not press that, my lord. We shall not press. That is all.
You're not pressing.
We shall not press because we say
Vairies challenge, my lord, the attorney general has to serve notice. Well, so that point goes. My lord, so far this is, my lord, my learned friend is relying on reported judgment. He has just now given to me. So far this point is concerned, my lord, Honorable Justice Soposatchi Bhattacharya passed an order, and against that, my lord, the Union of India has preferred an appeal. This is the MAT number. The appeal is pending. In that matter, I appeared, my lord, for the petitioner. Their fact was different, my lord. They were both not citizens of Bangladesh.
On that point,
And that is one point. That is one point. The other point was not that the sperm was collected, not and it was preserved with the sperm bank from the husband. Then he crossed the age limit. In that case, his lordship said that since it has been collected within age, the bar doesn't apply. So the facts are different here, my lord. Here, there is no.
Where is that order? You are having it?
It a car order. People, sir.
Fact is different. So I am not relying on this judgment at all, my lord. Their fact was different. Here, my lord, there is no participation of the husband.
On same ground.
No, here there is no participation of the husband.
No. And what has happened in the appeal?
Appeal is pending.
No stay.
no,
I'm not even that ratio we are not relying on because they are not the facts are different. There was participation of the husband. Husband not had donated this sperm. It was preserved within age. In this case, it's a third party.
COVID came, so the treatment could not be continued.
In that case, because of COVID, not there was a delay in treatment.
And they were Bangladeshi citizens.
And one of the main points taken by the union is that they are citizens of Bangladesh. They could not have obtained the order.
Yes. This is an unreported judgment. I shall have to consider and come back. Right?
When?
What do you think? One week. 1 week. Ensure. 1 week hence, your lordship.
As well, lordship.
Kerala High Court judgment.
You're for the state?
In an opinion.
Union of India?
Yes, sir.
Who is for the state? Other?
We have served, my lord.
Yes, sir.
We have served, my lord.
And your lordship kindly record that they are not placing the virus.
Yes. Learned counsel for the Union of India is present. None appears on behalf of the other respondent. The affidavit of service filed by the petitioner be kept in the record. The counsel for the petitioner submitted. He will not press if there be wherein the petitioner has challenged the section 21 within bracket G as ultra virus. 21G of attested productivity technology within bracket regulation act 2021 as ultra virus. Full stop. The counsel for the Union of India prays for time. Counsel for the petitioner has concluded the argument. Full stop. Counsel for the Union of India prays for time to go through the judgment relied by the unreported judgment relied by the petitioner in the case of Shamoli Shaha and others and another dated 22nd 11 22. Let the matter appear on 9th December 2024. The petition is directed to inform the next date of hearing to the state respondent.
Retaining the position, Lord, because
the same ending.
because the matter of Lord surrogate.
Under the same.
सर्विस ने भी की
कोणता
उधर जाने
कोणता
3 and 4 is ours, isn't it? But I appear for the respondent in the first matter and petitioner in the second matter.
Yes. Who is for the petitioner?
হ্যাঁ? আপনি করবেন না তাহলে আমি আমারটা করব।
Here the main issue is now, Mullah, regarding the writ petition of the younger son.
No, Lord, I tell your lordship,
The
Lord,
Prabhu
that
Mr. It's only part.
I am only on the point, Lord, that so far as the order passed by the Lord, the maintenance tribunal, Lord, so far as the quantum of maintenance, I am not, Lord, challenging before your lordship. Is within the jurisdiction. But when an application under section 5 has been filed by the mother praying for a maintenance from the sons, I am one of the sons, the other son is here before your lordship. I say, my lord, the tribunal do not have any jurisdiction to pass an order of eviction because it could have done so if it was under section 23 of the act.
Correct.
So, my lord, in support of that, I have brought some judgments to assist your lordship. That's my only basic point here. I am not there, my lord, and so far as their writ petition is concerned, but I say that the writ court is not the executing forum of, my lord, the order for making for compliance of that order.
Yes.
I'll first place a few basic facts for my writ petition, Mullah.
Your writ petition is
The
105.
first of the two. WPA 10504.
Correct.
And my lord will kindly turn to page 4.
Yes.
This is the paragraph which started in the previous page, paragraph 6, where the basic facts are stated in a nutshell. Well, if my lord chooses to go through it, but in a nutshell, my lord, the husband of my client passed away in 2018. The trouble started thereafter.
You are the mother.
Mother. She was a chronic patient of diabetes, which affected her kidneys. The case made out is she was never treated by either of her sons, and there was an opportunity because there was a marriage in a sibling's house. She had gone there, and from there she went to Cuttack, where her brother resided, to mainly for the treatment. Successive surgeries took place, eventually leading to removal of one kidney. She was better after that because the first surgery revealed, which was for removal of kidney stones, that the kidney could not be kept. It was in such a condition. Thereafter, she went back, but her return was not at all congenial. She's in her 70s, late 70s now. She was made to do the household course. The property in question is a 3-storied building. The first floor is let out by Mr. Mukherjee's client for commercial purposes. The ground floor, first floor is where the elder son resides, and second floor, Mr. Mukherjee's client resides.
Where you are residing now?
I am residing in my brother's house in Cuttack, Odisha, Cuttack. It was in Odisha that successive surgeries took place, and even a cataract surgery for.
Still you are in Odisha. Okay.
And even my husband, who died of cancer, liver cancer, he was also treated in Odisha because that was also a very gaudy, unhappy chapter. The return between 2019 and 23 was not happy, as I said. She was made to do all the household chores. She was not even provided. This house is in Midnapur, by the way.
Where is the order?
The order, there are 2 orders. One is at page 79. The other is at page 88. Page 79.
Yes. 6924.
Yes.
Opinion number one is first son.
Both of them were represented, both the brothers. And then the paragraph starting with heard the matter at length. It is ordered that opponent number one, that's the elder brother, and opponent number two, the younger brother, will vacate the building within 3 months from today. During this period, opponent number one, Gajanand Sharma, will pay 10,000 rupees as maintenance per month within 7th day, and the opponent number two will pay 15,000 per month. So this payment was an interim arrangement contemplated by the maintenance tribunal. This was only the interim order. Final order is, this is made absolute really at page 88. And my lord, the significant paragraph is the paragraph above that. The opponent number one and opponent number two state that they have no problem to vacate the property of the applicant, but ask for reasonable time for shifting.
Where from you are reading page 80?
Page 79.
79.
My lord, absolutely at the middle of the order. In bold, opponent number one and opponent number two. The paragraph has 2 lines.
Yes. No problem to vacate the, but ask the reasonable time. Yes, then.
Page 88 is the next order. There was no submission made from the end of the sons that this recording was not correct. They had ample time between page 79 and page 88. Many months had passed. Page 88 is dated 6 December 2024. So 3 months after the first order, the second order. In the interim, nothing was paid. Approval push.
Yes.
The significant thing, another significant thing, in the interim period, nothing was paid. Till I approached High Court, nothing was paid. And that was, my lord, more than 6 months after the second of the 2 orders was passed.
Yeah. Your time. As per your submission, the imping order, page 88, is correct order as a final order. Being
This
a
is
final
the-
order is you are supporting this.
Yes, the tribunal, there's no question about the tribunal lacking in jurisdiction.
No, not I am telling. See, 79 is the interim order.
Yes.
Correct.
Yes.
Now, page 88, your client stated that they have not complied with. So he has disposal only directed to pay within 30 days. So where is the reason and where is the finding?
The reason, whatever reason is there in the first order, page 79.
Correct. First order interim order.
Yes,
Order.
but the second order purports to affirm the first order, make the sort of interim order absolute.
Where is that?
The applicant Pushpa Sharma, I'm reading from page 79,
Correct.
states that she has a 3-storied building at Rangamati.
Correct. With
Yes.
regard to payment of maintenance and all these things. So directly pass an order, authority has passed an order to pay 10,000, 15,000. There should be a finding on what basis the amount has been adjudicated by the authority.
Be that as it may, the quantum is not seriously disputed by anybody. What is, they have joined issue with the fact that, Malad, the learned tribunal could not have passed an order directing the sons to vacate.
Yes.
And the maintenance was clearly an interim maintenance till they vacate. That is clear from the wording of page 79. And the description of the property is there in page 79. the fact that they are in occupation of the amount of property, my lord, ground floor utilized for commercial purpose, the other two where they reside, first and second floors.
Yes.
And the applicant is not able to stay at that house due to security reason, that has to stay at a relative's house. Her regular expenses as medical expenses are not fulfilled by the sons. Now but not for a moment, even before the tribunal, did they volunteer that I'll make any payment of any kind, 1,000, 2,000, 10,000, not even on the day the matter was disposed of. No amount was paid after the disposal in the 3 months period that went between the two orders, and after the disposal in the 6 months before I came to court, before the honorable judge taking the matters past directions. That itself, with respect, shows a total.
What is the prayer here?
Before I moved the writ petition, I had approached the district magistrate for enforcement of the order. Because the Act, my lord, section 22 contemplates that the enforcement agency is the district magistrate or his subordinates. But first I wrote to them that you have to make the payments. And then, my lord, at page 93, my lord will find my representation to the district magistrate.
Yes. Yes.
If my request as contained here is not carried out, what other remedy is there but to move the Honorable High Court? This is, my lord, in a nutshell, my writ petition. The letter addressed to my sons, my lord, after the order is at page 89.
Page 93 is by, this is a legal notice.
Legal notice in the sense that kindly assist the client is, my lord,
Under which provision the
section 22. I have, my lord, 2 books.
I can spare a copy for you.
I have 2 books are there.
book page 20,
Section 22.
yes. Implementing the provisions.
The West Bengal rules, my lord, that is also there in the book. My lord, that does not, my lord, envisage a mechanism for sort of in terms of section 22. No subordinate officer has been assigned the task by the various district magistrates. So, apart from addressing a letter to the district magistrate, my lord,
Yes.
the Act does not contemplate anything.
Okay.
But I'll place, my lord, the provisions of the Act. Before that, my lord, some other facts which are decipherable from the writ petition of the younger son.
Yes.
My lord, page 30. I'm on the second writ petition now. At pages 31 to 33,
Second writ petition.
yes. At page 33 is a
Second writ petition ekhane kahan hai?
That is my petition, I believe.
yes, WPA 16316. I think item 3
Writ petition kahan hai?
for item 4.
तब एक साथ क्यों बांध के रखते हैं? कौन बांध रहे हैं? Yes,
Page 33 is a trade license obtained by the younger son
Yes.
in respect of the ground floor. That was obtained Malad, on basis of a declaration purportedly issued by me at pages 31 and 32.
31 and 32 are?
It is not arranged in the proper order in my copy. Page 32 is the first page of the declaration, 31 is the second page. 2-page deck. Anyway, this was issued in the lifetime of my husband. The
Yes.
content of the declaration is at page 31. And it has been stated on oath that the signature is forged. And for ready reference, I'll request my lord to compare this signature with the signature of my client at my lord, pages in the application that she filed before the tribunal, page 69 of the first writ petition.
Yes.
And be that as it may, this was in the lifetime of my husband, and there's a dramatic change of scenario after my husband passed away in 2018.
Yes.
The second thing I want to show to my lord is, my lord, paragraphs 23 and 24 of the second writ petition. Here,
Paragraph
23 and 24. My copy does not have page numbers, so my lord, I cannot assist my lord with
23,
that.
24.
Page 6.
23, 24.
Yes, at the bottom of the page.
Yes.
Respondent number 3, there is my client at various ailments, including diabetes as well as kidney-related ailments. She required medical assistance and was under regular medication. The petitioner used to provide the respondent number 3 with required medicines and bear all expenses for providing medical facilities to her. Copies of the relevant documents evidencing, my lord, such medical assistance, my lord, are annexures P6. Well, if my lord kindly turns to page P6, pages 35 to 57.
Yes.
My lord will find that this entire bunch is of 2022.
Page starts from
35
35 to 57.
to 57. 23 pages. The entire bunch of prescriptions, some medical tests,
Yes.
are all of 2022.
Yes.
Whereas, my lord, I underwent my kidney surgeries in 2019. Those papers are annexed to the writ petition. So this averment in paragraph 23 as well as the next paragraph 24
So now here only the question you have asked as per your writ petition, you want the order passed by the authority
I want to return home. Firstly, I want to return to my.
to be executed. That is
Yes,
the case.
yes.
That
And
is to be executed.
yes. And my lord, kindly for a minute, my lord, paragraph 24.
Yes.
The top of the page, my lord. The respondent number 3 suffered from kidney stones. The doctor was of the view that there was high chance of infection if it is operated to remove the kidney stones, considering the fact that the respondent number 3 is diabetic. This must have been pre-surgery 2019, but there's nothing to support that I was ever taken to a doctor who would arrive at that opinion, because the medical prescriptions are all of 3 years later. The other thing, before the law point, Malad, page, I'm a little clumsy, Malad, I'm a little apologetic for that. Pages 58 and 59. Of the second writ petition.
Yes.
The pleading is that to instill a sense of confidence in the mother, in the ailing, unwell mother, this fixed deposit was created. This is in Haryana, where the native place of the petitioners, the ancestral land, everything is there. Malad, nothing has been stated. What is the status of the FD now? I apprehend that the money, if my lord turns to page 59,
Yes.
it was being renewed till 2024, and the maturity value is stated to be 1,86,000.
Yes.
We do not have the fixed deposit certificate. Technically, it belongs to me because it was out of my husband's money. Husband had agricultural land over there. He earned agricultural income and that. Now, Malad, these are the few unpleasant facts that I wanted to highlight to my lord, to really put across the predicament of my client. She's not happy in her relatives. She's a refuge there. She's in Odisha. They are taking good care of her. But she naturally wants to return home. She has a feeling of insecurity. Pursuant to a direction of Justice Amrita Sinha, the younger son had visited my client and also persuaded my client to return, but she was not willing. Now, my lord, let my lord address let my learned friend address my lord on the issue of law. I'll respond to that thereafter.
So far as my learned friends, Lord, the proposal that the mother is not welcome home. Lord, I am not standing in the way. Mother was with us. For some reason, the mother chose to live with her brothers at Cuttack. I had been to Cuttack to see and tried to convince her. But from the last, Lord, the monies that we have remitted to her, Lord, we find that there are number of Lord untoward Lord withdrawal by cash from the ATM account. We have checked up because on the last day my learned friend has given up. And Lord, there are a lot of Lord the withdrawals from her account, which we are really apprehensive about. Because Lord, this was handed over to the honorable court. No, is it before the court?
No.
Anyway, Lord, this is a different aspect of the matter, Lord. But we find that about Lord 45,000 and odd, Lord, that has been withdrawn, Lord, from the ATM account of the mother while she is staying with Lord her brothers. Now, Lord, be that as it may, Lord, now coming back, Lord, to the question about whether, Lord, the writ petition is maintainable or not before your Lordship, Lord, I address first.
Yes.
10 minutes. I'll take 10 minutes.
No.
I understand. My other friends are waiting, Lord. Now, Lord, so far as the point of law is concerned, my learned friend has relied upon section 22 But I say that instead of section 22, Lord, if we go back, Lord, to section 11, Lord, your Lordship will find, Lord, the enforcement of the maintenance orders are contemplated there. 22 is not only an enabling provision to the state government to appoint officers.
Correct.
But not the orders passed under section 9 on an application under section 5. Section 5 is not the provision, not entitling not an application for maintenance to be made by a senior citizen. The order of maintenance is passed under section 9 and its enforcement is covered under section 11. Subsection 2 is not as a very specific on that.
Yes.
Now, Lord, the order of maintenance, your Lordship will find that section 9, and this is not passed pursuant to an application of maintenance under section 5. Therefore, as of today, we are concerned about Lord 5, 9, and 11 with a provision for appeal that your Lordship will find at section 16, which is only confined to Lord the senior citizen, not Lord to the person against whom Lord the orders are passed.
Subsequently, I think there is a judgment of the division bench.
Lordship, but I'll come back on that. I have a judgment. I have a judgment to that. Even Lord on the, because my argument before your Lordship is, Lord, but the SDO does have a power to pass an order of maintenance, no doubt about it. So far as Lord the quantum of maintenance, he has to be Lord satisfied as to the need. Here, their application was for 30,000 rupees in their application, as we find under section 5. SDO, Lord, on an ad hoc basis, I must say, without going into, Lord, the merits and, Lord, the contention, somehow, Lord, jumped to a conclusion that we have given an undertaking that we will vacate, we will pay this much of amount. So, apart from, Lord, challenging the quality of the order, I say, Lord, that he could not have passed an order for direct vacating, which is the second part of that order, on an application under section 5, which does not contemplate, Lord, passing of an order for vacating, because it is only confined to maintenance. He could have done so if it was an action under Lord section 23.
Correct.
So, Lord, to that effect, Lord, I have some judgment to assist your Lordship, although it is very explicit from Lord the scheme of the statute. But there is one single bench judgment, and I'll also rely upon Lord a 3-bench of the Supreme Court, wherein Lord the ambit of section 23 has been taken care of.
Where is the application filed by the?
Yes, Lord, that is. Lord, in their application, Lord, other application, page 69 of their writ petition.
So citation key.
Citation, Acta unreported. But the amount of maintenance claimed, page 71, 30,000 per month. Item number 7. And reimbursement of hospital expenses, bills enclosed. So, page 71, top.
Yes.
So, this was not the ambit of the application.
Correct.
And this was not directed against 2 sons and a married daughter. That your Lordship will find at page 69 and 70. Mr. Gajanan Sharma, he is before your Lordship in person.
Yes.
My client Shamsundar Sharma and the daughter Sangeeta Sharma.
Yes.
It's not a party. No, she's a party. Why do you say? Maybe she is not in the writ petition because अरे भाई उसका अगेंस्ट में ऑर्डर नहीं हुआ उसको पार्टी नहीं बनाया इसमें क्या बड़ा बात है?
Yes. reimbursement officer and 30,000.
So these were, my lord, the twofold prayers.
Correct.
Yes. And she says at item number 11 at page 71 that applicant being looked after by her sister's family in Cuttack, Odisha.
Yes, not the law.
Sorry? No, that is an admitted position. The 20, there is not a case under 23. My lord. Now, my lord, your lordship will kindly come, my lord, in this context, my lord, the order sheets. There are 3 orders.
Yes.
The first 8th August 2024 at page 79.
Yes.
First order is not only not recording the receipt of a complaint. Second order is not 6th of September 2024. About the third paragraph, which starts with ground floor and second floor.
Yes.
The third line, the applicant is not able to stay at that house due to security reason and has to stay at relative's house. Her regular expense as well as medical expenses are not fulfilled by the opponents. Now the applicant wants the opponent should vacate her property mentioned above to use the premises for rental purpose to maintain her livelihood. Opponent number 1 states that they have no problem to vacate the property of the applicant but ask for reasonable time for shifting. This is not our case at all. We never said that we will be shifting. Heard the matter at length. It is ordered that opponent number 1 Gajanan Sharma and opponent number 2 Shamsundar Sharma will vacate the building within 3 months from today. During this period, opponent number 1 Gajendra Sharma will pay rupees 10,000 only per month within 7 days of every month, and opponent number 2 Shamsundar Sharma will pay 15,000, that is my client, only per month within 7th day of every month as maintenance cost of their mother in her bank account details, Cuttack, branch Odisha, account number such and such. They will also submit payment details on the date of hearing. Next date of hearing is fixed. Similar on the next date of hearing that your lordship will find at page 88.
Yes.
On 6th of December 2024.
Yes.
But all were present. On a query, it is stated that the applicant that her 2 sons have neither provided any monetary help to her nor vacated her residential property in compliance with the order dated such and such. Both of the opponents admitted her statement. Heard the matter at length, opponent number 1 such and such, opponent number 2 such and such are hereby directed to comply the order of the undersigned. Within such and such, the matter is disposed. Finished. They come up before this honorable court in writ petition. In the writ petition, your lordship will kindly see their prayers. They are trying to get a prayer which was not there in their application, first of all. But it all page 14. Yes, page 14. A writ of in the nature of mandamus directing the respondent number 5 and 6 to hand over vacant possession of the immovable property
Yes.
belonging to her at Rangamati, such and such, comprising 2 kata land with 3-story structure in terms of the order of the subdivisional officer, Mednipur, upon evicting the respondent number 5 and 6 in terms of the orders of the maintenance tribunal dated such and such. Thereafter, they are seeking compliance of the order dated 6th of December and 6th of September.
What is the order at 6th of December?
Well, that was the final, the order number 3. You are directed to comply the 6th September order.
Okay. Yes.
So it was first taken in August, then the September order, then followed with the December. And the writ petition is all about this, that they are asking for vacating.
Yes. Yes.
Now, my lord, therefore, it is not an application under 23. It could have never been an application under 23 because there was no transfer. Now, in such context, my lord, I am relying upon an unreported single bench first. I have handed over, my lord. That is in the case of Joya Roy, and another was the state of West Bengal. But this was, my lord, almost a similar case wherein, my lord, the paragraph 4 onwards. In this case, it was taken to the appellate.
Yes. Then what has happened? Appellate authority?
Then, Lord, then the Honorable Court says that, Lord, upon hearing the learned counsel for the parties and on bare perusal of the statute in question, it is evident that the impugned orders. I'm sorry. Para 8, Lord.
Appellate authority. What has happened to the appellate authority? Appellate court.
But that was not pertaining to that eviction order.
No, again, this order appeal is preferred.
No, not from this, because here in this case, Lord, it was from the order of the SDO carried it to the appellate tribunal, then before the High Court. That is what I meant to say. Then, Lord, paragraph 9, section 4 of the 2007 Act stipulates that a senior citizen, including parent who is unable to maintain himself from the own earning or out of the property, his own shall be entitled. Then, thereafter, Lord, the other sections have been, Lord, quoted. Then, Lord, 12.
Yes.
17. 17 is not only reiterating the rights of the parties. Lord. Lord, another division bench of this Honorable Court, 2022 SCC Online, Calcutta, 4552. Kindly take up, Lord, paragraph 7 onwards. Look.
Yes.
But 2005, what it is referred to is the PWDV, that is, Lord, domestic violence. Then kindly come to paragraph 17. I'm not, Lord, there are, Lord, the quotations from the judgments.
Yes.
Look, the last paragraph, 19. There was a direction from Lord giving back the possession. And Lord, so far as Lord, the Supreme Court, the three judges bench of the Supreme Court, which is reported in 2021, volume 15 Supreme Court cases, 730. But this deals with Lord the interplay between Lord the various provisions of Lord the Senior Citizens Act and the power to Lord direct eviction if it is an application under 23.
Yeah, 23, there is no dispute.
There's no dispute. There's no dispute about that. Therefore, this deals with this, Lord, paragraph 20 onwards, Lord, it deals with. Then paragraph 23, Lord, the position of section 23, how it can be, Lord, treated with, and Lord, the two subsections of section 23, what are the interactions between them?
Yes. Yes.
I'm not multiplying other judgments, Lord. So, Lord, to their writ petition, I say it is not maintainable. They have recourse to section 11. I am paying as of today. After the payment, as we find, Lord, that the accounts, Lord, there are certain, Lord, suspicious withdrawals. That's on fact. So far as, Lord, the order is concerned, which is subject matter of my challenge in the writ petition, the second writ petition.
Yes.
I say, Lord, the orders have been passed, Lord, without properly giving me an opportunity of hearing on, Lord, the merits. One, it was the amount were arrived at, Lord, in a summary manner. And, Lord, the SDO could not have passed an order of, Lord, eviction and direct vacating of the property under section 5. Because section 9 is, Lord, only an order of maintenance. It doesn't contemplate anything about vacating. But that is all for my submission.
Thank you. So what is your prayer in the writ?
That order to be set aside in my writ petition.
You prayed for the part set aside or total?
No, it is. I'll just check. Bakorota.
Court is set aside and cause the order date as 6 September.
Page 22. Page 22, Lord.
Prayer
directing, Lord, vacating of the property concern. Therefore, I've confined because that portion is without jurisdiction.
Yes. Yes. Thank you.
Lord.
एसडीओ ऑर्डर है ये जो लैंड का ये किया हुआ तातीगढ़िया जेएल 150
थोड़ा ये माइक लेके
एसडीओ का ऑर्डर में है जेएल 151 लैंड का जो डिस्क्रिप्शन दिया गया जो लैंड का कॉपी जमा दिया है लैंड का कॉपी इसमें है पेज नंबर 18-19
पेज नंबर 18-19
हाँ
कौन सा रिट पिटीशन
पहला या दूसरा वाला रिट पिटीशन
कौन सा रिट पिटीशन उनका इनका या
my writ petition, Lord, what is stated is that incorrect deed was annexed to the writ petition, deed of another property which has been sold, but it is admitted that the property in dispute is in my name and it is in Rangamati, the address and all is complete. It was in Bengali, so I could not really make out, and I do not have the deed of the property which is in occupation of the private respondents in my reputation. That was an incorrect deed which was.
Yes.
एसडीओ में ये डेट दिया गया है और ऑलरेडी ये सेल किया हुआ है 97 में।
किसने सेल किया?
वही पिटिशनर।
आज के डेट में जमीन किसके नाम पे है?
कौन सा?
जो घर वाला है
वो बुजुर्गों का, किसी के पास कोई पेपर नहीं है।
किसी का नाम में तो होगा
ना कोई पेपर नहीं है सर, ये भी कोई पेपर सबमिट नहीं किया।
दादा के नाम पे है कि परदादा के नाम पे है, किसके नाम पे?
कोई पेपर ही नहीं है।
तो खजना जो टैक्स किसके नाम से बनता है?
कुछ नहीं बनता सर।
ठीक है, चलिए।
और ये इसमें 151 है, जेएल नंबर हम रहता है 150 में, 150 में जेएल नंबर।
वन फिफ्टी,
हाँ।
और वो वाला
और थ्री स्टोरी है,
इसमें क्या नंबर है?
150 और उसमें 151 एसडीओ का ऑर्डर में।
यस।
और ये 3 स्टोरी बिल्डिंग का इनके पास से कोई पेपर जमा नहीं हुआ इसमें, ना कोई रिकॉर्ड है ना कोई पेपर है इनके पास। और हम भी 60 साल से देख रहा है, वहां कोई पेपर नहीं है।
यस। और कुछ
ना बस सर। और सर ये मेंटेनेंस का जो खर्चा है वो मेरे से दिया नहीं जा रहा, वो कम किया जाए।
आप पैसा पे रहे हैं?
हाँ दे रहे हैं।
ठीक,
वो कम किया जाए सर।
But first, Malad, I'll deal with the judgments, Malad, cited. The Honorable Division Bench judgment of the Honorable Chief Justice Srivastava. There, if
yes.
If my Lord turns to page paragraph 7, this is the judgment, Malad, Shwati Das. Paragraph 7.
Yes.
Here, the senior citizen, they had not approached the maintenance tribunal at all. But kindly sees, having heard.
Petition. This is the order against the single bench.
Yes, it was dismissed primarily because the statutory remedy was not availed of. It is noticed that it is not a case where the respondent number 4 had invoked the provisions of the Act of 2007 before the tribunal by filing any application in terms of Section 5 of the Act. But without invoking the provisions of the tribunal, but the Honorable High Court had been approached.
Yes.
So naturally, my Lord, without exhausting the remedy, a writ petition really could not lie. The other single bench judgment cited, my Lord, the case of Joya Roy.
Yes.
If my Lord kindly turns to paragraph 11.
Yes.
The respondent number, page 3, paragraph. Respondent number 5 in the writ petition ticks all the wrong boxes in the present case. First, the said respondent is not a senior citizen vis-a-vis the writ petitioners. Since the writ petitioners are not relatives of the respondent number 5 as defined in section 2G of the Act of 2007. Secondly, the respondent number 5 is not a senior citizen who has proved himself to be unable to maintain himself from his own earning or out of the property owned by him. Thirdly, the respondent number 5 is not a child. But so here again, Malad, it is easily distinguishable on facts. Who has approached the court, Malad? Yes. And the third decision cited, but I am heavily relying on this. Vanita. If my Lord kindly turns to paragraph 20. Oh, I have a bunch of my own, my lord. It's a little embarrassing, but
What?
a bunch of judgments which I want to cite.
Could have been cited earlier, so they can.
No, this was cited earlier, but there are other judgments. Anyway, I'll place this from here. And it comes to paragraph 20. And now, my lord, in paragraph 21, the statute, section 23 is quoted.
Yes.
23.1 and 23.2 are quite different. 23.1, where any senior citizen who after commencement of this act has transferred by way of gift or otherwise his property, subject to the condition that the transferee shall provide the basic amenities and basic physical needs to the transferor.
That is with regard to the deed and
I am not covered, but 23.2.
Yes.
Where any senior citizen has a right to receive maintenance out of an estate and such estate or part thereof is transferred, the right to receive maintenance may be enforced against the transferee if the transferee has notice of the right or if the transfer is gratuitous, but not against the transferee for consideration and without notice of the right. Here, my lord, in this decision, transfer, the word transfer, the expression transfer, has been stated to be not just transfer of ownership, but transfer of any interest. That is there, my lord, in paragraph 24. Paragraph 24.
The main contention is that under section 5 or section 9 can pass an order for eviction.
Very well so, because
Show me.
eviction is an incident.
Show me.
Yes. Kindly read paragraph 24 first.
Yes.
Another distinction between subsection 1 and subsection 2 of section 23 must also be noticed. Under subsection 20, subsection 1, we are not concerned with that. A few lines below. Subsection 2, in contradistinction, I'm reading the fourth line from the bottom.
Yes, yes, yes.
Stipulates that the right to receive maintenance can be enforced against a gratuitous transferee or a transferee with notice of the pre-existing right of a citizen to receive maintenance out of an estate, notwithstanding who is the transferee of the estate. In keeping with the salutary public purpose underlying the enactment of the legislation, the expression transfer would include not only an absolute transfer of the property, but also transfer of a right or interest in the property. This would also be in consonance with the provisions of section 2F, which defines the expression property to include rights or interests of such property. The expression transfer not having been defined specifically by the legislature, it must receive an interpretation which would advance the beneficent object and purpose of its provisions. Subsection 2 of section 23 speaks of the enforcement of the right to receive maintenance, which is more comprehensive in nature than merely enforcing an order for maintenance passed under section 9. The next paragraph, my lord. The substance of subsection 2 of section 23 as submitted by second and third is that the tribunal had the jurisdiction to pass an order directing eviction of the appellant, who is their daughter-in-law. According to the submission, the power to order eviction is implicit in the provision guaranteeing a right to receive maintenance out of an estate and the enforcement of that right. In supporting that submission, they have referred to the views which have been taken by several high courts and so and so. I'm not going on that. A few lines below that, the tribunal under section Senior Citizens Act may have the authority to order an eviction if it is necessary and expedient to ensure maintenance and protection of the senior citizen or parent. Eviction, in other words, would be an incident of the enforcement of the right to receive maintenance, which would be an incident of the enforcement of the right to maintenance and protection. Not merely maintenance, the quantum of money, but my security, my protection. And there, my lord, this case was then distinguished. It is a case where the daughter-in-law has approached court and so on. So the tribunal, my lord, I assert with respect, very much has the authority to order eviction as an incident of A, maintenance, and B, protection. Protection of the life of the senior citizen. If she is not comfortable living there under the same roof with her hostile children,
Correct.
the tribunal will interfere.
But you filed an application under section 9, sorry. Court initially interim order is passed. Subsequently, a date was fixed. And on that date, the interim order was confirmed. It is not your case, the attachment or the eviction order passed during the execution. If the tribunal under the citizenship may have the authority to order of an eviction.
Yes.
If the payment is not made, it is not the case under the eviction.
That is why section 22 was invoked. I could not have invoked section 11. Section 22, section 11 only for the maintenance part.
Correct.
Section 22, the district.
You have not. I am on the order of the magistrate authority. Authority, you have initiated the case for the maintenance. Interim order was passed. Interim order was passed. Subsequently, interim order was confirmed. With regard to the eviction.
The maintenance was only an interim arrangement.
Correct. Correct.
That is why.
That was confirmed in the subsequent order of 6 September.
Yes. No, the payments were directed till eviction was made.
Correct.
After eviction, payments need not be made.
Cannot be. Whether by absoluting the order, the authority can say this is an execution.
The magistrate did not execute the order.
So that kindly read this. The tribunal under the citizen may have the authority to order of eviction if it is necessary, expedient to ensure the maintenance. First, the maintenance.
Nothing was paid.
That's why that is not the application for execution of the maintenance order. That is not before the 6/9/2022.
Apart from maintenance, there is also the question of a residence, of a security.
So that's again you mingling up. Go one by one. You filed an application for maintenance, but the magistrate has passed an order. You vacate, or till that you pay 10,000 and 15,000. Interim order was passed. Subsequently, matter was taken on 6 September. 6 September, on that day, there is no application of the execution. Mind, please keep it in mind. That is not the execution of application for execution. That is for deciding the matter on merit after the interim order.
Yes.
On merit, can say it is the expedient.
But I did complain that nothing was paid. That is recorded. That is
nothing was paid. But that is not the execution. That is the
execution part came later.
In the confirmation order, you pass an order of attach on the
My lord, kindly, my lord, this is just a proposition of law. Kindly permits me to place the judgments,
yes,
but where such an order has been upheld by various courts.
Why you cannot given the judgment prior to that, before the argument?
No, because this petition was his. He was moving the second petition.
Okay, then
I'm responding to
other matters are fixed at 3. Then come on the next day.
So if I learn to indicate
What are the judgment you provide to Mr. Mukherjee? I am fixing another date so the matter can be.
Enough.
Counsel for the petitioner has concluded his argument. Counsel for the respondents are also concluded their argument. But in reply, learned counsel for the petitioner intending to rely upon certain judgments. Accordingly, the petitioner is directed to provide the copy of the judgment with the petitioner relying upon to the respondent. Let the matter appear on.
Not too far away, but not far away.
कौन सा डेट होगा? डेट है
লাস্ট দাও এটা দাও দশটা দেবে
डेट बीच में या तक नेक्स्ट वीक
দরকার নেই। তুমি আসতে পারলে না
ना
हेलो के लिए दाও हेलो के लिए
चार को है चार को थर्सडे है थर्सडे तो क्या हियरिंग है ना ठीक है रख दो इसको 12 बजे रखो नहीं 2 बजे रखो 4th December at 2 PM 4th December
তুমি বলে দাও আগে তোমার
Fixed code actually, on pay. Well, only my lord, I am paying for one indulgence, my lord. Item number 37. It was 21, 31, 37. My lord, my apprehension, they will proceed before the MSME council. Already they have proceeded, my lord, yesterday. My lord, 37, maybe fixed, my lord, tomorrow.
37 है ना कल ऊपर कर दो
Yes. May I have my lord kindly to
the appellate side
original side.
My lord, you will now take up the matter now. You will take up the matter now, 37.
come tomorrow
Tomorrow. 37 along with the other matter.
I will take your matter if you come up after 3:30 I will take it
Tomorrow, my lord, tomorrow.
if you both are ready to come at 3:30 I will take the matter no problem
Then tomorrow, my lord.
Many of them are ready to do it at even 3:30, my lord.
Tomorrow, my lord.
Huh?
37 tomorrow, my lord.
tomorrow come
এটার সঙ্গে 37 এর সঙ্গে এটা থাকবে ভাগের দিনও বলেছি অ্যাপলেট সাইড ওনাকে দিন এই 37 টা কাল or maybe fix some time my lord 37
আরে tomorrow it will be talk
it is in the list
টপে রাখবে টপে জজের মতন উপরে থাকবে My lord, with your lordships, kindly I'm mentioning, my lord, 5 matters, lordship remembers, my lord, there was a fight whether it would be heard by the coordinate bench or by your lordship. And lordship, finally, my lord, by the order of 18th of November said that the file be placed before the office of the, my lord, Honorable Chief Justice. Now, in the meantime, in 2 writ petitions, the interim order is expiring. It's still in, the file is still there before the, my lord, office of the Honorable Chief Justice. Kindly, my lord,
Because when the matter
then
is
we can have it heard. We can have it
the
heard, my lord.
matter is already before the Honorable Chief Justice, my lord, let it be decided which court would take up.
I had, my lord, pointed this out. Lordship said that if it is not, my lord, the issue is not decided within that time, lordship will consider the interim.
20th, my lord, interim order is till 20th, my lord. Let that be decided if it on 20th, by 20th it is not decided.
the interim order is up till which date
28th of November. Kindly keeps it as to be mentioned tomorrow.
Let it be fixed on Friday only itself. Let the Chief Justice decide, my lord.
okay,
We have made
come tomorrow as to be mentioned come tomorrow as to be mentioned
Grateful, my lord.
Lord, may I mention, my lord, a writ petition on the original side for withdrawal. My lord, kindly consider listening it tomorrow. Unconditional withdrawal. Grateful.
Lord, may I permit you to mention item number 112, my lord. The writ petition, my lord, wherein the petitioner has filed a writ petition wherein the petitioner's homestay license application has been arbitrarily turned down by the authority, my lord. The matter was lastly heard for the first time on 27th October. Thereafter, before Justice
what is
Sinha,
the urgency
my lord, the petitioner is suffering from huge financial loss because they are restrained from running their business, my lord.
who restrained
But my lord, the municipal authority, my lord.
huh
The municipal authority. So, my lord, that is a difficulty, my lord. My lord,
so what you want
my lord, the matter is listed item number 112. If my lord will preference will
come
be
at
given.
3:30 today I will take come at 3:30 with the other side come at 3:30 I will take if it is so urgent yes next
For judgment, item number 1.
I considered all the submissions. I find that the applications filed by both the petitions are not barred by limitation and rejected. And I am fixing one date for argument on merit. A date दो argument prior to पहले दो number. Second December.
My lord. But so far as the main matter is concerned, we had already argued it, my lord. But that was. I'll just
earlier.
refresh. I'll just refresh my lord's mind, my lord.
That's why it was earlier. No, there
I'll
are
be.
so many things. are
I'll be
there.
referring, my lord, from the written notes, my lord, that we have already filed. So, my lord, I have dismissed both the applications, my lord. Grateful to, extremely grateful.
नहीं उसको रहने दो बाद में पहले यार इनका एविडेंस चलने दो बाद में ले लेंगे Yes.
Witnesses. Again, 3:30. We've got tomorrow, the last day, hopefully, Mr. Dutt will get it.
Lord, I was told both Mr. Dutt and Mr. Ghosh was addressing courtroom number 40. Mr. Ghosh is here, my leader is not there.
Yes, start.
Yes.
May I, the corrections we have done in red. And
Copy to the other
I'm
side.
giving. If
they go through.
And then we'll file it in court.
First you go through. If there is a dispute, then otherwise it will go to my court officer. They will correct.
Very few.
They can.
Yes.
We'll just go through it.
Yes, that's why you go.
Then on the next, tomorrow we can file.
Cross examination resume.
Mr. Sethia, I suggested to you that both SL Sethia Liners and Drum Place Limited were debtors of the plaintiff bank.
I do not agree.
I further suggested to you that SL Sethia Liners and Drum Place Limited was maintaining an account with the Central Bank of India, London branch.
It appears so from the records produced by the bank.
I further suggested to you that both SL Sethia Liners and Drum Place Limited had a debt which was far in excess of rupees 20 lakhs with the Central Bank of India.
I do not agree that SL Sethia Liners Limited had any debt to the Central Bank of India. The bank has produced nothing to prove it. The bank has produced, in 40 years of litigation, one photocopy of a decree against Drum Place Limited, a default judgment, and no other document to connect that judgment with the fixed deposit of RK Agencies Limited. It does not concern RK Agencies Limited. The photocopy of the default judgment was produced for the first time in 1990. although the suit began in 1987.
I suggested to you that both SL Setia Liners Limited and Drumplace Limited was controlled by Ranjit Singh Setia.
I have already answered this question. They were group companies of House of Setia Limited.
This is a suggestion. You first agree or disagree and then you can answer.
I disagree. This was a group company. These were both group companies of House of Setia Limited, where Ranjit Setia was one of 3 directors and shareholders. The other 2 directors, Sampath Setia and Indra Setia, outvoted him on the board. Indra Setia.
Go slow because he has to
Indra Setia
outvoted Ranjit Setia on the board of directors and in the register of shareholders.
I suggested to you that on the instruction of Ranjit Singh Setia, the defendant number 1 through R.K. Khanna deposited the amount of rupees 20 lakhs with the plaintiff bank for adjusting the dues of SL Setia Liners and Drumplace Limited.
The money would have been deposited.
First say yes or no and then you answer.
I disagree.
It is a suggestion.
I disagree. The money would have been deposited on the instruction of Mr. Bhattacharjee. And Mr. Bhattacharjee, as a director of the company, which Mr. Ranjit Setia was not, was bound to follow the Companies Act, the Income Tax Act, and the Foreign Exchange Regulation Act, even if he wanted to give a loan to a third party.
Yes, next.
Why do you say Foreign Exchange Regulation Act?
Because the loan was to be given to a foreigner.
Which foreigner?
It was never decided.
I suggested to you that the foreigner you are referring to was SL Setia Liners and or Drumplace Limited.
In 38...
This is a suggestion. You please agree or disagree and then you can answer, volunteer.
I cannot agree or disagree to such a suggestion because I have had numerous such suggestions made by the bank in the course of 38 years of litigation. In 1987, the suggestion was that the foreigner...
Slow.
Go slow.
In
1987, the suggestion was that the foreigner was SL Setia Liners Limited and or Drumplace Limited. In 2004, the written statement said that the foreigner was Ranjit Setia. In 2006, the bank amended the written statement to say that the foreigner was the bank account of Setia Group of Companies, which did not even exist. It was invented for the first time in 2006. In 2014, before the division bench, on the last day of hearing, the bank said that the foreigner is Drumplace Limited. In the Supreme Court...
Go slow.
It's a long list.
Yes. You can go slow. Let your answer be recorded.
Yes.
In the Supreme Court, the bank came forward and said that Drumplace Limited had nothing to do with the fixed deposit of RK Agencies Limited. I would like, if I may, to refer to that, the second additional judge's brief.
Second additional judge's brief of documents.
Second additional judge.
Yeah. Page 43 of the second additional brief. Paragraph 4B. I state, sorry, in inverted commas, I state that the said deposit was categorically made with the respondent bank against the indebtedness of SL Setia Liners Limited to the respondent bank in London, on the understanding that this deposit was to be used as set-off against the said debts arising out of legal proceedings against SL Setia Liners Limited and Ranjit Setia before the English courts, close inverted commas. So in the Supreme Court, the bank contended that the fixed deposit had nothing to do with Drum Place Limited. There is no decree against SL Setia Liners Limited or Ranjit Setia in favor of the bank. And it is very hard for me to know exactly which of the many stories of the bank I am supposed to be defending today. Therefore, it's not possible to answer your question simply.
Shown paragraph 4B at page 43 of the second additional judge's brief of document. You have just now referred to this statement. Are you relying on this?
My point was that this statement was a statement made by the bank.
Question repeated.
I'm not relying on it. It is a very long affidavit. I'm just pointing out the content.
I am not relying on it. It is just an affidavit of the bank.
Correct. Thank you, sir.
I cannot agree or disagree. I cannot agree or disagree. The suggestion which I have given you with regard to the foreigner's account, for which you have deposed that you cannot agree or disagree, is based on the understanding of yours that you do not have any knowledge about it. Am I correct?
No, I disagree. I would say that the identity of the foreigner's account ceases to have relevance because the money was deposited for remittance to the foreigner's account, subject to permission of the Reserve Bank of India, at the very least. And the permission of the Reserve Bank of India was denied on the 14th of January, 1986. And the bank has been illegally withholding the money of RK Agencies Limited ever since, or before that even.
Mr. Setia, please understand my suggestion. I am not asking you or suggesting to you about the procedure with regard to the foreigner's account. I am asking you about the name of the foreigner's account.
I am saying that it is not clear from the records and it is irrelevant.
It is irrelevant. What records are you referring to?
I think There are 8 volumes of records here.
And in none of the document as disclosed in the 8 volumes of records before this honorable court, there is a mention of the foreigner's account.
There is the mention of the foreigner's account, and there are numerous alternatives given for the identity of the foreigner by the bank. There is no clarity as to who the foreigner is.
But you will agree with me that the bank is referring to 2 companies which were incorporated in London by the name of SL Setia Liners and Drum Place Limited. Am I correct?
Yes, and much more besides. The bank is also referring to an account of Setia Group of companies, which does not exist and never did.
Will I be correct if I say that, sorry, এটা কেটে দিন। I suggested to you that the amount deposited by Mr. R.K. Khanna by way of his letter, by way of his letter dated 27/11/1984 was to be kept under lien by the bank.
I don't think my answer will change if you ask it 5 more times.
Yes or no?
Then I answered it yesterday.
What do you accept my suggestion?
My answer is on the record.
Please give the answer. What are the court?
Please repeat the question. I've lost it.
Question take to put it in.
Repeat the question.
Yes, for any debt of RK Agencies Limited.
Shown exhibit A3. You have A3, A by 3. ওই 27/11/84, page 6, judge's brief. A by 3. A by 3. Page 6. You have used an expression. For account of RK agencies বলে আগের আনসারটাতে any debt. You have used an expression for any debt within inverted comma for any debt of RK agencies inverted comma close. Is it evident from this letter?
I think the lawyers will answer that question, but that is what a lien is.
No. The letter has been put to you. Whether that is mentioned
My
in the letter.
understanding, yeah.
Have you find anything in the
In
letter?
my opinion, it is evident from the letter that a lien can only cover the debt of RK agency. It is also evident. It is also evident from the letter of lien.
Identify. Sorry.
It is evident from the letter that a lien can only cover the debt of the lienor. And it is also evident from the text of the letter of lien, which is A4, I don't know. Next page, A4.
Letter which is available at page
A4, page 8.
Exhibit A4, page
8.
Page 8.
I suggest it to you that the lien was never created for the debt of RK agencies, but for settling the debts of SL Setia Liners and Drumplace Limited.
I disagree.
Now, I further suggested to you that it was the obligation of the defendant number 1 to apply for permission from the RBI to transmit the amount of rupees 20 lakhs to the credit of the London branch.
This was a defense taken by the bank.
I am putting you a suggestion. You please agree or disagree. And
I
then-
disagree. This was a defense taken by the bank in 1987. It was adjudicated. May I have volume 1? Page 47. I'm quoting from the judgment of the division bench. From inverted commas, from the letter, it is not clear who was to apply for permission. Full stop. The bank applied for permission that the Reserve Bank declined. Full stop. Hence, the purpose for which the amount was kept in deposit was frustrated. Full stop, close inverted commas.
I suggested to you that this was not the ultimate finding of the Honorable Appeal Court.
I disagree. I mean, I'm sorry. May I revise the answer?
Then says
this was a part of the ultimate finding of the division bench.
yes, next.
I suggested to you that by way of a letter dated 14 January 1986, the Reserve Bank of India has stated that no permission is required to transmit any amount to the overseas bank Indian branch bank towards recovery of dues of foreign borrower held under lien in India in accordance with the FEMA Act. What do you have to say to that?
The letter should be shown to my witness. It's an exhibit.
Which document you are relying upon?
Let him say. If he wants to refer it, I will show it.
Sorry, are you suggesting to me that the Reserve Bank of India wrote what they wrote? Yes, they did. But may I see it?
One. Exhibit 17. Shown exhibit 17.
Sorry. Which letter is this? This is not the letter of 14th of January 1986.
Sorry. Sorry. Page 29. Page 29. Exhibit A by 14.
The question is,
page.
Later date tag আছে. Later date tag আছে.
Page 144 then.
না এটাকে
The Reserve Bank of India replied on 14th of January 1986 to the application of the bank dated 29th of November 1985. And they replied in terms of the application made by the bank. It should be added here that during evidence, the plaintiff's witness has deposed that the bank was prevented from returning the money after the denial of permission by the Reserve Bank of India because the Reserve Bank of India blocked the account, the fixed deposit account, after this reply was given. It's important to note that there was an interval of over 8 months between this denial of permission and the blocking of the fixed deposit account.
Shown page 144 being exhibit 17. I suggested to you that by way of the letter dated 9th October 2016, the Reserve Bank of India has clarified that the permission to set off deposit under lien did not come under the purview of Foreign Exchange Management Act 1999. And the bank was advised to be guided to the other extant banking regulation in this regard.
This was a letter written by the Reserve Bank of India to the bank in reply to their letter, which is disclosed at page 147. The copy of that letter is not clear, but a clean copy was submitted earlier in the proceedings by me. What transpired is that in the hearing before the Supreme Court, their lordships asked the bank to obtain the opinion of the Reserve Bank of India. On the 26th of September 2016. The letter on page 147, which is not clear to read, wrote to the Reserve Bank of India, and instead of giving an opinion, the Reserve Bank of India washed its hands of the matter by this letter. This letter was produced before the Supreme Court by the bank's advocates on the 10th of March 2017. Dissatisfied, their lordships dismissed the petition of the bank.
Yes.
Lord, may I continue on the next?
Supreme Court has dismissed their appeal. So I think it's a good place to end.
Supreme Court have dismissed the appeal.
Independent
This is the best place.
Cross-examination resumed. but due to paucity of time,
তিন
could not be
আমারটা
completed.
কোথায় গেল
Let the matter appear tomorrow at
একেবারে ফাইনাল একদিন করে
তাহলে সেটা
tomorrow.
একটুখানি আপনি
Yes. Let it run. Yes.
No, but I was about to mention Marot, regarding item 1 Marot. Instead of second Marot, may it be taken up on the 1st of December.
কপি দাও
1st December, I don't.
Second, I have to leave the court early actually, Marot. It's a matter.
मतलब sorry
1st December. 3 बजे तक. 1st December.
Grateful, my dear.
मेरी आज के मालूम affiliate side matter मालूम
No appellate. Let the original complete.
मतलब item number 32 मतलब the arrest warrant was issued मतलब they should मतलब the contemner should be produced before a lordship मतलब
Parvesh Shukla.
yes
Yes, my lord.
Surrender before the consent department.
now मतलब the alarming part is that मतलब that despite there being a my lord's order and मतलब the rule has been issued मतलब kindly consider मतलब again मतलब 2 days back 48 hours back मतलब until unless he is being put into prison he will continue with this मतलब kindly consider this मतलब posts मतलब kindly takes मतलब page 3 he has been मतलब deprecating the court also page 3
Yes.
in today's corporate world the irony is that when someone calls out unethical practices the first reaction from the guilty is often to be hide behind the shield of defamation. But the truth is simple, wrongdoing doesn't become right just because someone threatened legal action. Ethical conduct is not defined by lawsuits, it is defined by actions. And no matter how much noise is made to the silence the truth, unethical behavior remains what it is. 2 days back, kindly see the kindly hashtag, everybody has been tagged. Now kindly see the first page top 2 days back. He has to put back behind the bars. He doesn't give any the magnanimity of this court is being put to rest.
He does not file any appeal objection. He is vacating the
2 days back.
Yes. Any advocates are there?
यस सर पहले मैंने एक एडवोकेट एक्चुअली रखा था बट वो उन्होंने मुझे रिप्लाई नहीं किया मैंने काफी बार उनसे कनेक्ट किया बट रिप्लाई नहीं किया अभी नए एडवोकेट मैं अपॉइंट कर रहा हूँ सर
कौन है?
सर
Your Lordship, till now, my lord, I have not filed the new Wakalatnama. He's entrusting me at this point of time. What he has said to me, as per instruction, my lord, I am saying that in the plaint, my lord, erstwhile advocates appeared, but they have not informed him anything about the plaint, what it happened, or the orders which were passed by the honorable court. And
No, nobody has
2 days
appeared
back.
at any
We
point.
have served the order on him.
Nobody has appeared at any point of time.
no, my lord, in the plaint,
He
my
has
lord.
given the reply in the WhatsApp, thank you, received, but he has not appeared.
Yes, my lord, he has said that he
He
has.
has received the message. The
Yes, my lord,
notice
by stating
saying
thank you.
that thank you,
Yes, my lord.
but nobody has appeared.
माय लॉर्ड वो जो मैसेज भेजा था वो 12 नवंबर का था और
हाँ।
14 तारीख को मुझको आने के लिए भेजा
Correct.
तो मैंने उनसे ये पूछा था कि आप अपनी
कौन
आईडी
वकील है आपका? कौन था वकील?
उस टाइम पे वकील नहीं था
तो आपने तो वकील को बोला था
Yes,
ना? कौन वकील? वकील का नाम क्या है?
सनवाल टिब्रेवाल
हाँ?
सनवाल टिब्रेवाल
तो कभी अपेयर नहीं हुए यहाँ पे?
And nobody has appeared by that name.
Nobody has appeared in the matter.
सर 12 नवंबर को जो उन्होंने मैसेज भेजा था शाम
Whatever it may be, ठीक आपने भेजा था. Why you are publishing again and again? Once you had a knowledge with regard to the interim order passed by this court.
नहीं मैं सर उसके बाद मैंने कुछ भी पोस्ट नहीं
Yes,
किया है
2 days back.
ये
2 days
I mean, these
back.
are all poor.
नहीं ऐसा कुछ भी नहीं है
हाँ,
ऐसा कुछ भी नहीं है.
क्या नहीं है कुछ भी?
आफ्टर जब मुझे पता चल गया कि ये अभी एक्सटेंशन हुआ है उसके बाद मैंने नहीं पोस्ट किया सर
ये कब का है?
2 days.
क्या है उसमें, क्या लिखा हुआ है सर? आप चेक कर लीजिए, ऐसा कुछ भी नहीं है जो कि
But he is in complete denial mode, my lord, I think.
Yes, he will not, my lord, until and is put behind bars, he will not, my lord, come to terms.
मालूम है इसमें क्या लिखा है?
जी
मालूम है क्या लिखा है? बताइए आप बोले ना इसका कुछ लिखा हुआ नहीं है, बताइए क्या लिखा है इसमें?
देखना पड़ेगा मुझे सर।
मैं दे रहा हूँ, लीजिए।
दे कॉपी दे, ओना के दे। আমাদের একটা কপি দে।
सॉरी माय लॉर्ड, बट इसमें मतलब ये लिखा है कि एक लेसन बनता है, कुछ लोग ऐसे होते हैं जो लाइफ में सिखा करके जाते हैं।
पढ़िए, लास्ट थर्ड पेज पढ़िए।
He is aware of everything, defamation, bullshit. He is posting pictures of the petitioner. With the pictures he is posting, the photographs.
Yes, so in that picture I am also there.
Maybe, but once the court has passed an order with regard to this petitioner, why you are publishing? Might be why you are publishing in the paper this all these items when there is an interim order.
सॉरी माय लॉर्ड, मुझे इसके बारे में अवेयर नहीं था।
ठीक है, जाइए 2 दिन रहिए आराम से, पता
Yes, 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 yes.
और क्या कर सकते हैं? आप
भाई-
वकील नहीं कर रहे हो, अभी हम आपको छोड़ेंगे, कल आप फिर भाग जाएंगे, फिर यहाँ से हम
नहीं नहीं सर, मैं खुद से आया हूँ, आप जब भी बोलेंगे मैं यहाँ पे आ जाऊंगा माय लॉर्ड।
My lord, he undertakes that he
मुंबई में रहता हूँ माय
will
लॉर्ड,
not
मैं इधर पे
post my
कोलकाता में नहीं रहता।
To be further restrained from posting this kind of mail, otherwise
Lord,
the magnanimity of this court is put to rest.
he undertakes that he'll not post, my lord.
2 days back,
Kindly record that undertaking, my lord.
yes, kindly records that.
Kindly record that undertaking.
This posted 2 days back.
पब्लिश करेंगे जब
यस
तक
प्रॉमिस माय लॉर्ड, मैं नहीं करूंगा कुछ भी अभी।
कहाँ रहते हैं?
मुंबई सर।
आप क्यों कोर्ट में क्यों नहीं आते जब नोटिस मिला है तो आपको?
सर 12 नवंबर को मुझे शाम को नोटिस मिला, अगर मैं ट्रेन से भी आता हूँ 36 आवर्स लगता है मुझे। 14 तारीख को
आपको तो व्हाट्सएप में भेजा था, तो आपने व्हाट्सएप में जो वकील को भेज देना था।
वकील को मैंने
थैंक यू बोलो से बोलना था, आई रिक्वायर सम टाइम।
वकील को माय लॉर्ड यहाँ आने के बाद मैंने अभी ढूंढा कि कौन से वकील को रखना है, वैसा हुआ।
नहीं, आपने जिस व्हाट्सएप मैसेज में आपको नोटिस मिला था, आपने उसमें थैंक यू भेजा, तो उसमें आप बोल देते कि मुझे 2 दिन का टाइम दीजिए, मैं आके रिप्लाई दूंगा। आपने तो नहीं किया वो, उस व्हाट्सएप में आपने तो थंब दिखा के थैंक यू कर दिए थे।
थैंक यू फॉर शेयरिंग किया था कि जो उन्होंने किया, तो कि मुझे मतलब थैंक यू फॉर शेयरिंग ऐसा था माय लॉर्ड। आई एम सॉरी माय लॉर्ड, अभी मेरी तरफ से कुछ भी नहीं।
alleged contemner has surrendered before the Deputy Sheriff of Calcutta against the warrant of arrest issued against him. Full stop. Accordingly, the contemner has been placed before this court. Full stop. Learned counsel for the petitioner has handed over the documents. That is the publication dated. What is the date?
2 days, Millet, from today, Millet, 2 days back means 9th.
There is no date.
9th.
The document stating that in spite of the interim order passed by this court, and in spite of warrant issued against the alleged contemner, the
It should be 19th.
Contemner is publishing the item against the contents against the petitioner. Full stop. The alleged contemner, Mr. What is the good name?
परिवेश शुक्ला।
Parivesh Shukla submits that made an undertaking before this court that henceforth he will not publish any article against the petitioner and will appear before this court as and when required by this court. Full stop. In view of the undertaking given by the petitioner in open court, the petitioner is released, the alleged contemner is released on personal bond of rupees 20,000 with the direction to appear before this court as and when required by this court. When is the next date?
Well, today was the date.
Today is the date fixed.
My lord, he has to answer to the rule, my lord, if your lordship,
Full stop.
I don't know.
Yes, what do you say?
He has to
But I
answer
think
the rule.
Answer to the rule, my lord. So, my lord, I don't know whether he answered. Last time he did not.
I am not recalling the rule. That's let it be.
My lord.
As the alleged contemners had surrendered him voluntarily before this court, accordingly, for the time being, the rule is being kept in abeyance. Be kept in abeyance. Full stop. आप रिप्लाई कहीं फाइल करेंगे इसमें
Within 1 week.
हाँ
1 week.
कंप्लायंस फाइल करना है आपको
1 week, yes, sir.
The alleged complaint director submits that he may be granted 1 week time to file affidavit of compliance. Let affidavit of compliance be filed within a week after serving the copy to the London Counsel for the petitioner. The petitioner is liberty to file reply within a week thereafter. List the matter on 16th of December.
My lord, warrant to be kept in abeyance, not the rule. My lord says rule to be kept in abeyance.
Warrant, huh?
Warrant.
Warrant, well.
Warrant be kept in abeyance.
Grateful.
My lord, may I be permitted to mention a very
Your
urgent
lordship, my lord,
appellate?
my junior had mentioned the matter, my lord, your lordship said to serve notice and come. It's a very short matter, but I do not know whether it was only moved once. It is appearing as 112. But there is no direction as it is. But we have only challenged their inaction in not granting a license for homestay. And we have applied for homestay registration. They have not taken any steps. During the pendency of the writ petition, my lord, we have received a communication that it cannot be granted because you are not an individual, you are a company. The rules do not contain any such prohibition that only an individual can apply, a company cannot apply. If the company is the owner of the property, who else will apply? Your lordship can.
My lord, I am appearing on behalf of the state, my lord. In this matter, my lord, the petitioner, my lord, what done, my lord? The petitioner applied for registration of the homestay.
Do one thing. How soon you will file the report by an affidavit? How soon you will file the report?
My lord, kindly give accommodation so that the report may be submitted. But before that, one thing, my lord, to be important here is that, my lord, the petitioner applied for the registration of the homestay in the residential premises.
Okay, that's why I'm telling you, file the report by way of an affidavit.
My lord.
Supply the copy, and they will file the exception if any. And I am fixing the date.
My lord, my lord.
How soon you will file?
My lord, 2 weeks.
You have already given
Report.
the order.
You are already having the file. Only you have to type and file it.
It has to be annexed. Here
Within 10 days.
10 days, my lord.
Well, may I suggest
Item number?
Item 112. But I can suggest this. I have already been communicated the order by them. I can place it before your lordship by supplementary affidavit.
For what?
Because that is the order they have passed. Lord, I am now challenging that order actually.
You challenge it? After the writ petition?
After the writ petition, I have got the order.
Okay. So
Lord, I will have to press my grounds, Lord, here only. I have already prepared a supplementary affidavit annexing this order. I will make my submissions on this, my lord.
Okay, then report is not recorded. If the order is there, all the things is in the order.
Yes,
so they cannot improve that.
They cannot improve that. That is what I'm saying. Your lordship will take this supplementary affidavit on record, which the order is annexed here, and your lordship will keep it any day, my lord. I shall make my argument.
Let the copy be supplied.
Yes, yes.
The counsel for the petition has filed supplementary, and the London Counsel for the petition submits that during the pendency of the present date application, the respondents have passed the impugn order rejecting the claim of the petitioner for grant of license for operating homestay. Let the supplementary affidavit be, and the London Counsel for the petitioner prays for leave to file supplementary affidavit by disclosing the impugn order. Full stop. Let the supplementary affidavit be kept with the record. After the petition directed to serve the copy of the same to the London Counsel for the state for the respondents. List the matter on 9th, 8th or 9th. When our time will be. आने दो ऊपर कर दो 9th at the top कर
Obliged.
9th at the top.
Lord, one. Lord, Lordship recalls not one, Lord, the PPM investment, Madam Lord, BBM versus my lord, State of West Bengal matter had appeared before is to be mentioned before my lord. My lord, instead of the plaintiff note for correction of the order, the amount to be paid by the Reserve Bank instead of the state. Lordship, because your lordship asked the other clarifying, my lord. My lord, yesterday, my lord, I got the information the amount has been paid by the state. So not that some lord, now that my lord, since the amount has been paid, no need for Reserve Bank to pay again. So not could it appear is to be mentioned, my lord, so that I can inform the other side and
To be mentioned,
not I'll give
but
the
inform the other side.
I will. Not they've got the money, so I've got the receipt. I'm grateful. I'm
Not file the appeal.
No. We paid the amount.
My lord, may I have your lordship kind leave to my lord move a appellate side matter, my lord, unlisted, my lord, there is grave urgency in this matter. Your lordship, my lord, has the occasion to my lord hear out two writ petition with regard to the license, my lord, granted by the defense authority in respect of my lord the shop. One, my lord, at the Ekbalpur, my lord, the command hospital, and another one at Bias. Now, what happened is this, my lord, a writ petition has been filed that is pending. During the interregnum period, my lord, what happened? They have, my lord, rejected my application for renewal, despite, my lord, of the fact that their clause 6 provides that always, my lord, the
Yes, I have in my order it is mentioned.
yes, now this is another matter, my lord. So what they have done, they have issued a peremptory notice that I have to evict by 30th November, my lord. So therefore, my lord, I want to file this, let it, my lord, appear tomorrow in the list. Otherwise, my lord, it will become impactuous. But in the meantime, if I have evicted, my lord,
Where is the order?
My lord, the order, I have annexed it, my lord.
Which page?
The rejection, my lord, will appear annexure P7, my lord. A communication made by them, my lord, under the letter dated 6 November 2025. They have categorically stated, my lord. Let it appear tomorrow, my lord, I will. And I also, my lord, sought dispensation of Rule 26, my lord.
Leave granted, leave granted to affirm the affidavit and to list on 28.
Let it appear tomorrow, my lord. I have also.
28.
Huh? 28.
May I have your lordship kindly to mention the matter?
28 as urgent motion.
As urgent motion.
May I have your lordship's kind leave to mention a matter? But this is regarding that Ukil Bhedi, my lord, on 11th of November 2025. Ukil Bhedi, the filling up of, my lord, a water body. My lord, by 11th of November 2025, the lordship has already passed an order giving directions. Now, my lord, in the meantime, what is happening? The corporation is completely filling, my lord, clearing the Bhedi and already taking action, my lord, to make the application infructuous. My lord, I have taken your lordship's views very seriously. I am already taking out an application for implementation of KMC. Well, let the matter appear once in the lordship list on Monday. In the meantime, I'll take out an application for addition of KMC.
Your lordship, I have been served with the copy. In this matter, they had preferred appeal against the refusal of the interim order. Division bench had sent back the matter because the matter, similar matter is pending before the NGT. After considering all these facts, your lordship had directed let the affidavits be completed. They, in the garb of filling up the water body, complaining of the water body is not allowing the KMC to clear the water body. What the KMC is doing, I am the person, I am a party in the proceedings. I am a party in the proceedings. Then why you have served the copy to me? If I am no one, why you have served? Then let me speak. Then let me speak. Your lordship, you cannot hijack my right of submission.
Let the KMC
I am appearing before the lordship. I have the right to make my submission before the lordship. Kindly see what they are wanting is to create pressure upon the KMC so that the water body is not cleared, and that is why they are stopping this, your lordship. The affidavit direction is there. The affidavit direction is there. On the earlier occasion, your lordship. On the earlier occasion.
Okay, let it appear in the list. I'll make that application also.
On the earlier occasion, your lordship will remember.
Come on 28.
20th.
28.
28.
28 urgent motion.